we are back in session. It is still January 15, 2019. And this afternoon, we have four public works items. We'll probably take the first three of those. That's items 13A, B, and C. And then we will, if Mr. Dingell's available, we'll jump back to item 7C, the first reading on the county courthouse matter. So for the next at least hour or so, we'll be working on the public works items. So at this time, I'll move to our first item, which is item 13A, first reading and setting the second reading and public hearing on ordinance number PA 1365 in the matter of amending the rural comprehensive plan to redesignate land from forest land to marginal land, to rezone land from impacted forest land F2 to marginal land ML, and adopt savings and severability clauses, file 509 PA 16-05291. The applicant is Martinez. And for the benefit of the public and board, I'll say that this is not our decision on this issue. It is simply a formal reading of it, and then setting a public hearing. And the public hearing date is in the materials that have been proposed by staff. Commissioners can ask questions if they want on the matter. We typically have a brief time for doing this. And if people want to ask more questions about it, what we do is we have the term first reading, meaning that in the olden days before the internet, the actual commissioners would actually read this stuff out loud, and then people 2 weeks later would have a public hearing on it. So today we're dispensing with the reading of it, except to say we're having a reading, and you have now read it or can read it, and we'll have the public hearing. We can entertain a motion if someone wants to make a motion to set the second reading and public hearing on the ordinance. Is there anyone that wishes to be recognized to make a motion? Commissioner Buck.
So I move on item 13A to set a second reading and public hearing.
Yep.
For ordinance number PA 1365 in the matter of amending the rural comprehensive plan to redesignate land from forest land to marginal land, to rezone land from impacted forest land F2 to marginal land, and adopt savings and severability clauses, file 509-PA 16-05291.
Okay, and do we have the date of the public hearing so the motion could include the date of that public hearing?
Yeah, it's scheduled for January 29th, 2019.
Okay.
At 1:30 time certain.
Okay, and I'll ask, is that acceptable to you to have that part of your motion?
Yes, it is.
Date and time? Okay, is there someone that wishes to be recognized to second the motion?
I'll second the motion.
Okay. Okay, the motion's been made by Commissioner Buck, seconded by Commissioner Bozovich to set the public hearing and a second reading of this ordinance, proposed ordinance. We typically have a voice vote on this, although when we have an ordinance, we typically have a recorded vote where you get to state your vote, and Mr. Mokrzycki gets to poll the commissioners in compliance with the Lane County Charter. So this time, is there any further comment on this before we move to a vote? Okay, seeing none, all those in favor, please say aye.
Aye.
All those opposed, please say no. The vote is 5-0, and the motion's adopted. and we'll see you back here for the public hearing. Thank you very much for your stellar answering to all the questions the commissioners had. Okay, so now with 13B, first reading and setting the second reading and public hearing on ordinance number PA 1366 in a matter of amending the rural comprehensive plan to redesignate land from residential rural to residential commercial, to rezone land from rural residential RR5 to rural commercial RC, and adopting savings and severability clauses. File number 509 PA 1705144, applicant On the Way Incorporated. And this is the same kind of thing where we simply need a motion to approve it. If there's any commissioners that have any questions, they can ask them. Otherwise, we are setting the public hearing and second reading and public hearing. Do any commissioners wish to be recognized to make such a motion?
So moved?
Okay, it's been moved. Is there a second?
What's the date of the second reading?
It would also be January 29th at 1:30 PM, time certain.
Okay, so that should be part of the motion, January 29, 1:30.
Okay.
Okay, I'll ask the maker, is that okay with you?
Yes, it is.
Okay, and is the second okay with that too? Okay, moved by Commissioner Buck, seconded by Commissioner Bozovich. And any further discussion? Seeing none, take the vote. All those in favor, please say aye.
Aye.
All those please opposed, say no. And the motion carries 5-0. So now we're up to 13C, which is our sixth reading and reopened public hearing on ordinance 18-08 in the matter of amending Lane Code 16.090 definitions, LC 16.210 F1 zone, LC 16-211 F2 zone, LC 16.212 EFU zone, LC 16.214 ML zone, and LC 16.264 telecommunications towers standards to update definitions, modernize terminology, enhance the user experience by simplifying the code, streamline review process, and align the code more closely with state law, and adopting a savings and severability clause, file number 509-PA 18-05035. And this item has been, as it indicates, a sixth reading. It's been here before several times. The county received assistance from the Department of Land Conservation Development to help develop this. It was fairly seriously modified last year by the board. We're now reopening the public hearing on this. At the conclusion of the public hearing and staff presentation, we can go a number of different options. We can ask more questions. We can have another public hearing. We can direct staff to rewrite it and come back and have another public hearing. A lot of different options, and I'm sure the staff will go over those. Do you want, staff, do you want to make a presentation at this time before we have the public hearing?
We would, thank you.
Okay.
There are a few procedural items on the script beginning at number 3.
Okay. Thank you for, yes, and you were kind enough to
write.
write that out.
Open the
So
Read those.
do we want to read the purpose of the public hearing after you make your staff presentation?
If you could do it prior to the staff presentation and first open the hearing, that would be great.
Okay, very good. So today we are having a renewed, reopened public hearing on this ordinance, which is 18-08. And at this time, I'm going to open the public hearing, explain the rules of today's reopened public hearing. First is that today is still January 15, 2019. This is a public hearing that's been reopened based on consideration that further revisions were made after the close of the initial hearing and open record period to proposed amendments, specifically to citing standards and proposed guest house use provisions. While public testimony will not be limited to these items, the board is especially interested in testimony relating to citing standards and the deletion of the proposed guest house use. The proposed Lane Code amendments are subject to applicable criteria identified in Lane Code 12.005, 12.050, and 16.252, parenthesis 2. The order of proceedings of this hearing will be first a report by staff, followed by public testimony, then additional comments by staff, and then consideration by the Board of Commissioners. Failure to raise an issue with sufficient specificity to enable a response may preclude an appeal to the Land Use Board of Appeals on that issue. Prior to the conclusion of the public hearing, any participant may request that the record be left open for an opportunity to present additional written evidence or arguments regarding the application. The board's decision may be appealed to the Land Use Board of Appeals in accordance with ORS Chapter 179. At this time, I'll call for any disclosure of any abstentions due to conflict of interest or biases. And this is a legislative matter, right?
Correct.
Okay, so for purposes of conflict of interest, this is a legislative matter. Any conflicts of interest? Seeing none. And then I'll ask the audience, you've seen that none of the commissioners have any intent to have abstention due to conflict of interest. So if there's anyone in the audience that wishes to be recognized, I'll call on them now to make a challenge to any of the commissioners' statements that they do not have a conflict of interest. Okay, seeing none. At this time, we will turn this over to Ms. Amber Bell, and he'll hear the presentation by staff, followed by the public hearing.
Thank you, Chair. Good afternoon, Commissioners. Amber Bell, Senior Planner with Land Management Division. This is a sixth reading and reopen hearing of Ordinance 1808. It's a code modernization project for Lane Code Chapter 16 resource zones. On December 11th, the board reopened the record and hearing after several revisions were made to the siting standards, and the proposed guest house use were deleted after the close of the initial public hearing and close of the record. Those changes have been fully summarized in the board's packet, so I won't reiterate each of them in detail at this time, but in general, they included revisions that were directed by the board at the November 27th fourth reading, that included deleting the clear and objective siting standards in the F1, F2, and EFU zones, deleting the type 2 or 3 siting standards in the forest zones, and then replacing those siting standards with the standards that are in our currently adopted code language. It also included deleting the proposed guest house uses and associated standards from the F1, F2, EFU, and marginal land zones, and then clarifying that the 200 by 200 foot same site measurement that is currently applicable to replacement dwellings and accessory structures would remain applicable to those uses in the forest and EFU zones. Additionally, per staff's recommendation and the board's direction on December 11th, staff revised the F1 zone proposed language to include a planning director determination of permitted or type 1 uses for a proposal, and that's processed through a type 2 planning director review procedure with notice. It is an option that an applicant can request, and that was added back in for consistency with the EFU zone and F2 zones. And I'll also note that it's currently found in the F2 and EFU zones, so that's consistent with the proposal and the currently adopted code language. These changes, have been made to the ordinance and have been provided to the board. And staff have also included in the board's packet comments that were received from the public prior to September 11th, the initial public hearing, but they were not yet included in the record due to the fact that they were emailed into a staff member who was on leave and not forwarded on to another staff member, but we wanted to make sure that they were placed before you and are in the record for your consideration. The board packet also includes comments that were received during the period from December 6th through December 21st, and we've also received comments since the publication of the staff report up into today. Comments that were received through 10:30 a.m. this morning were distributed earlier to the commissioners, and identical copies of those comments have been provided to the commissioners. A paper copy has been provided, and paper copies are also available at the back of the room. In summary, comments that were raised have to do with the review process, fire siting standards, including fuel breaks, forest siting standards, and timeline extensions. Many of these issues have been addressed through the prior board proceedings and in the board packet. For instance, there were issues raised concerning timeline extensions, and those were addressed with some language that was added to the board ordinance that clarified that the board's intent was not to prohibit timeline extensions based on any changes to the siting standards that had been proposed. And then later that was addressed further by the fact that the replacement or the proposed siting standards were replaced with the currently adopted standards, which staff understand was partly in response to concerns that were raised regarding timeline extensions. This concludes staff's presentation at this time. However, we would be happy to answer any questions that you have regarding the proposed code amendments or the public comments that have been raised.
Okay, so there's a huge amount of material here, and there'll be questions from the commissioners. Commissioner Bozovich?
Real quick question. After I saw the email with the 10:30 and prior, I forwarded you a couple more emails that came directly to commissioners for the record. Did you receive those two emails concerning this ordinance?
I did see a couple emails come across, but we didn't have sufficient time to
Right. It
forward
went
them
to
through
all
the board
commissioners,
office.
but I just want to make sure those two emails got in the record.
I believe Commissioner Bozovich, legal counsel, will correct me if I'm wrong, but because the entire board received those materials, I believe those are in the record. Is that correct?
Yeah, if that's the case, if those emails came to the entire board, they're technically
They weren't included
not
in the
rejected by
packet.
the board, they're
They
received.
they were, instead of addressed to the standard, all commissioners' email, they were addressed individually, so it didn't get to staff, so I want to make sure you guys got those. That's all I was checking
And
on.
I'll add, once we have time, we'd be happy to make those available to the public on our Code Modernization Project website.
So just on that point of the emails, do the commissioners forward emails to you that they received on this topic, or how is that, what procedure do you want followed for that?
What I would recommend from the planning director's perspective is that those emails be either forwarded to the planner on, like Amber Bell is the senior planner, she's the project manager. We assign planners to lead these, whatever the projects. So they are the ones who organize that. So if you know who that is, it can go directly. It can always come to me or Keir Miller, the planning supervisor, because once it comes in from you all into the division, then we will distribute it to the appropriate planner so they can put it in the record.
Okay, and Mr. Clark, do we report legislative contacts for purposes of this hearing?
In terms of ex parte communications?
yeah.
No, you
No,
don't have
because
that.
it's a legislative hearing?
Correct, yes. And I think the request for bias that you made earlier takes into account any of those issues.
Very good. Just want to highlight for the commissioners that we do have typically two types of land use proceedings. We have legislative proceedings where we're making rules and we're interpreting, we're making a code. In this case, we're amending a code. And there are other types of hearings we have where we are applying the code. The code is already written, somebody wants to do something, typically somebody doesn't want them to do it, we have a hearing. That's a quasi-judicial hearing. And there are rules for the how you conduct those hearings are different, and this is the wider, open type legislative hearing. Okay, any other questions before we go to the public hearing? You're done with your staff presentation. Any other questions from commissioners? Okay, I'm really interested in the siting standards. The more I'm concerned about what happened in California and the amount of danger that's associated with putting houses on rural land. I'm wondering if you can, I think I previously talked about this in terms of the California standards being, I would say more safe. How do the standards in this proposal stand compared to what we saw in, which didn't work in California, but has higher standards in California? Just curious about the narrowing it down to the issue of siting standards for fire safety.
Chair Sorensen, thank you. I'll address that question. Lydia Kay, Planning Director and Division Manager. So the current siting standards that are before the board today are the siting standards that are in our current Chapter 16. And the discussion, we had a discussion about some siting standards that staff brought forward that we believed were more consistent with the way that the statutes and rules are written. Those are one set of rules. With regards to your overall question, we haven't done, staff hasn't done a detailed analysis of the, CAL FIRE codes as compared to the Oregon codes. There are numbers, there are, as you well know, layers and layers and layers of codes. So fire codes aren't something the Land Management Division writes. In the building department, we would implement fire codes through our building permit process, the way that we implement land use regulations through our land use process. So, it's very complex in terms of understanding and answering the question, how do our codes compare to the ones in California, and are they better or worse? But the forest siting standards in our mind are one of the many things that are relevant to that question.
So as I'm hearing it, there's a current standard that's in our current code. There's a proposed standard that you made that was taken out of this document by previous board decision last year. And then I'm asking you about yet another set of standards. So there's at least three.
And we can do more of a detailed presentation if the board so directs. We have a FireWise program. Keir Miller, the planning supervisor, works with the fire chiefs and the districts. I mean, there's a number of different things that are going on. And, I would say land management has a very small piece of that. There's other agencies that are really more designed to address those more directly.
Could you describe the differences between the current siting standards that are in the current code and the staff proposed siting standards that were taken out during one of the 6 readings we've had on this?
So I'll address that. So there's a few things. One was in the forest zones, there was one standard that staff had proposed regarding or clarifying that pre-clearing, pre-grading, pre-thinning, things of those nature would not meet the siting standards, the forest siting standards. That has since been removed. That was a new proposed standard. It's not currently in the adopted code. In the forest zones, the Oregon administrative rules set or provide the rules for forest siting standards as well as fire siting standards for structures and dwellings. The fire siting standards are in the currently adopted code as well as the proposed amendments. The forest siting standards, we were proposing to add in pretty much the verbatim language into the forest zones. That language has since been removed and replaced with the currently adopted language. The currently adopted language provides an interpretation of how those standards could be met. It was adopted through a local interpretation that it met the OAR. We haven't done a full analysis of whether or not the currently adopted standards meet the OAR forest siting standards. But that is, the OAR does provide a provision that allows local interpretation and adoption of local standards to meet those. The other difference is that in the previous draft, we had proposed clear and objective standards, and then discretionary standards, type 2 or 3 standards, and the clear and objective standards have since been removed, and that's more consistent with the currently adopted code.
So the clear and objective standards were removed.
In the forest zones and the EFU zone.
Okay. Okay, any other questions by commissioners? Go ahead.
Thank you. So the current language in code and what's currently proposed under 1808, that language is a local interpretation of OAR that has been acknowledged by the state?
Correct, in the forest zones.
Right. And that development of that local interpretation of OAR, how was that developed? Was that developed with the input of the Oregon Department of Forestry and local fire districts and forest managers and supervisors? I believe there was a task force to develop that.
I'd have to go back and look at the ordinance and the ordinance history. I don't know off the top of my head.
You don't ask a question you don't know the answer to. Yes, they were involved in developing that code. So, you know, whether one code has higher fire standards than the other, the code we currently have in was developed with fire professionals and forest professionals' input and has been acknowledged by the state.
Okay, any further comments by commissioners before we go to the public hearing? So at this time, I will ask for the list. It is coming via the old-fashioned method, not the internet. And we just have a few people that have signed up. This is very technical. Are these all on the same ordinance? Yep, they're all on the same ordinance. So I'm going to, are these in order, in any particular order, Ms. Williams? Okay. Let's see, who signed up first? Make sure I'm starting with the right sheet, okay. And then, okay, good, all right. So I'd like to suggest a 5-minute presentation by each of the people on the list, given the size of what it is we're considering here and the large number of issues involved. So to get everyone an opportunity. Having said that, I would like, if you have heard what someone else has said, I'd like to suggest that you not take your full time. So at this time, I'll call Mr. Robert Emmons from Fall Creek. I will set the timer, 5 minutes. Please introduce yourself. Make sure I've properly introduced you, and please begin.
Thank you. Yes, you have properly introduced me, but let me add a few things. Welcome, new commissioners, Buck and Bernie, and good afternoon. I am Robert Emmons. I live at 40093 Little Fall Creek Road in Fall Creek. And I'll be offering these comments on my own behalf, but also on behalf of Land Watch Lane County. Our research analyst, Laurie Siegel, will be providing further comments as well. So superficially, a discussion of amendments to a chapter in Lane Code would seem to be of little interest to and consequence to an average resident of Lane County. Fairly abstruse, arcane for most people, I think. However, the uses and siting standards permitted on farm and forest land can have profound impacts on the health of Lane County, the safety of their inhabitants, and on climate change. I'm going to defer comments about uses in the various zones and the conflation of those uses, the intermingling, the blending of those to our research analyst, Laurie Siegel. But I want to say that in reference to what you started, Commissioner Sorensen, to explore the concerns about fire issues, that, we're entering our 4th year of drought. And it's evident, it should be evident to anybody around that our countryside now is starting to show a lot of dead trees, particularly our conifers, which are the base of our forest economy. And so I would think that that's one issue, but just overall safety is the predominant one that should make wildfire safeguards a priority for Lane County. Yet, in our experience, Land Watch, our experience has been that in permitting, the county has permitted the siting of dwellings on forested slopes and on slopes greater than 8%, typically to facilitate a view that radically increase the risk of catastrophic fire and the first responder accessibility. We urge the board to, without going any further into these issues, those are just one or two that surface, others will be covered by other people, without doubt. We urge the board to insist on siting standards that reduce rather than increase the risk of wildfire. And lastly, I want to make, and I would suggest that to make an informed and representative decision regarding these and other issues embodied in this process, I would urge the board to delay a vote for adoption for at least a month. Thank you.
Thank you. Okay, next up is Roger Leach from Cottage Grove, followed by Mike Evans, followed by Norm Waterbury. So Roger Leach next. Welcome.
Thank you.
Please give your name and where you live, and we'll get you 5 minutes if you need it.
Thank you. I doubt if I need 5 minutes. My name is Roger Leach. I live at 841 South 1st Street in Cottage Grove, Oregon. My family and my wife's family both have been in Cottage Grove for 6 generations. I might not be as prepared as some people. I really don't understand all of the wording. I haven't talked to anybody, legally to explain it better to me, but it appeared to me that it seems like it would be harder to get a extension on a land use permit on F2 zoned property. My wife and I and my brother each bought 20 acres up around Drina Lake a few years ago, and the only reason that we haven't started building our dream home and our hopefully retirement someday is because of the fire code requirements for building that Lane County already has in place. We haven't been able to afford to widen the roads for service vehicles and put a new bridge in. It's got a bridge that's adequate for building on the property, but not for a fire service vehicle to pass another car on the bridge, and it requires turnouts on the roads. So we've got a beautiful piece of property we hope to retire on and have our grandkids visit us up there, but I think that the passing of the changes on this would make it to where we can no longer get an extension. The land use on our property was acquired 11 years ago, and the only reason that we bought the property that we did was because it already had in place a approved home site that we could build our home on, our 200 by 200, and that can't be moved or anything. But it also requires that all of these roads and bridge split things be put in place before we can exercise the use of our permit. So I know that if that is the case, by November this year, by November 1st, when our permit expires, if I can't get extended, it's more than $100,000 to redo the bridge to Lane County codes. And I mean, just the permits alone, going through the Department of Forestry and going through, it has to be engineered, it has to be Department of Wetlands, sign off on it. encountered hoop after hoop jumping through. So right now it's a beautiful piece of property that we're trying to keep the roads clear and keep the vegetation down and the overgrowth in the home area. But it's a lot of work. Our family's been up there working on it for years with our children and, you know, swimming hole in the creek, all that kind of stuff. And I urge you not to vote for anything that's going to make it harder for the families that already have land use permits to be able to use them to get the extensions, just so that we can meet all of the lane codes in the finishing of our house and our projects. That's all I have. Thank you.
Thank you very much. We are now going to hear from Mike Evans, followed by Norm Waterbury and George Greer. So welcome, Mr. Evans. If you give your name and address, we will give you up to 5 minutes.
Thank you, Commissioners, and welcome Commissioner Buck and Commissioner Bernie. A little bit of introduction. I'm a planning consultant. I worked for Lane County for about 6 years, many, many years ago, and have been a planning consultant since. And I'm testifying on behalf of the, I'd like to think, the landowning public segment of the Lane County population. You haven't, the new commissioners haven't been involved, but this process is what has been explained as being described as a modernization of existing county code that was long due for the last 30 years, it's been said. And so chapters 13, 14, and now 16 have gone through the process of being rewritten, modernized, so to speak. Chapter 13 has been adopted, Chapter 14 has been adopted, and this is pending adoption, and hopefully today. The difference between the changes that were made that resulted in this hearing were basically the deletion of changes that existed previously in the other versions of the code. They were brought about largely because of, well, the modernization process was supposed to result in a policy-neutral product. It was supposed to modernize the framework of the code, bring it up to date, but the policies within the existing code were not supposed to be changed any more than absolutely positive. This last version, as you can see, deleted changes that were going to change policy issues. One of the primary effects of that, and why I urged their deletion, or at least some of them, was that, as Mr. Leach explained, those folks out there who have permits to build and are pending, they're given a certain time limit, and they can get 1-year extension. That is, if the code hasn't been changed. If the code is changed, then the 1-year extensions are no longer allowed. So for that reason alone, it was important to a lot of folks to have those previous proposed policy changes deleted and resulting in the code that's before you today. There may be a desire on the part of the commissioners to look into some of the fire safety standards. As Mr. Bozovich mentioned, the staff proposed revisions to the code went back to the original OAR standards, which are much more subjective than what the county has in its current code and what is now before you, just the retention of current code. As Mr. Bozovich mentioned, there were stakeholder groups involving the fire department, Department of Forestry, forest owners, individual property owners, of course the staff, DLCD, involved in developing the fire safety standards that exist today. I would tell you that they're much more strict than what happens by just going back, or what can happen by just relying on the original OAR language. And all counties didn't do that. If there's an interest in, as has been suggested, of applying fire standards beyond the forest zones, in the EFU zone, in the rural residential zones, then that's something I think that the county commissioners, if you want to consider that, then that should be taken up in a different forum. I think you need to put together a task force with stakeholder groups, people who are knowledgeable about fire protection. And if the existing standards need to be changed, then change it through that process. And if they should be applied to other zones, then they can be applied at that time. This is not the forum to do that, nor are you even capable of doing that in the other zones other than those that already contain fire safety standards. So with that, I do thank the board, planning commission, staff for the about 4 years of work that's gone into this product, and I urge you to adopt the code as presented before you tonight and put this project behind us. It's a very good product, much better than what we had before. There are things that I'd like to see changed myself if I had my way, but everybody in the room has their own ideas about what the code should look like. Thank you very much.
Thank you very much. And let's see, we're up to Norm Waterbury, followed by George Greer, followed by Lori Siegel. So is Norm here? Okay, well, I'll come back to him. Is George Greer here? Welcome, Mr. Greer. And if you could just introduce yourself, where you live, and I'll give you 5 minutes.
Certainly. Thank you. My name is George Greer. I've lived and farmed at 1342 and a half 66th Street in the Thurston area of Springfield for over 40 years. I think that it's possible that pending legislation in this session may mean that we're closer to the beginning of this conversation than the end of it. The housing crisis has meant that there's going to be more elaborate discussion about having accessory dwelling units on rural residential land, and that discussion has already brought up the need for looking at siting in forest zones because of fire protection issues. So those things may come out of this legislative session. Regardless of that, I think that I'm here today to provide maybe a little higher altitude perspective on this. I was a Lane County Planning Commissioner at the time the Rural Comprehensive Plan was adopted. At that time, the major threats to ag land were conversion to non-resource use and adjacent conflicting uses. Existing code focuses on these. However, Goal 3 states agricultural land shall be preserved for farm use consistent with existing and future needs. Very little entered into the record addresses future needs. Farming requires infrastructure and a labor pool, not just land. I'd like you to consider that the average age of a farmer in Oregon is 60. In 2016, OSU forecasts that 10.4 million acres, or 64% of Oregon's ag lands, will change hands in less than 20 years. It's becoming increasingly difficult for my wife and I to operate our farm without help. It's extraordinarily hard to find someone willing to do this work. We want to continue to farm and age in place here. But the reality today is no family members are going to move home and help us do that. For us and many others in our situation, the difference could be in providing housing for an employee. Currently, it's a tortuous path to site an accessory structure on EFU land. Whatever the outcome of this code modernization effort, I urge the Commission to consider that without the tools to successfully transfer farmland to the next generation, Oregon will inevitably lose a significant amount of its agricultural base. Provisions for accessory structures will always provide a potential for inappropriate proliferation and abuse. Unless there's a commitment to support the resources necessary for compliance and enforcement, abuses will continue, and so will lawsuits. Our world and the challenges facing our local community are significantly different than they were 30 years ago. This process provides a unique opportunity to not just clean up some language and clarify the code. It also offers a chance to look forward at what needs to change in Lane County. I would urge you to do that. Thank you for this time.
Thank you. Okay. Next, we have Lori Siegel, followed by William Dunham, followed by Jim Mann, and followed by David Hemingway and Jim Belknap. So welcome, Ms. Siegel. You'll have 5 minutes to address the board.
Thank you, Commissioners. My name is Lori Siegel, and I'm going to speak on behalf of Landwatch Lane County. First, I wanted to mention that I would like the Commissioners and staff to have a discussion about the financial considerations that were mentioned earlier by Commissioner Sorensen regarding the financial resources that the state provided to the county to help with this code modernization project. I don't think Lane County was the only county to who received funds to modernize their code, but the fact that so much of the work has been turned back at the end of the process raises the question about those resources. So it'd be interesting and helpful if there was a discussion about that at some point. I'm going to speak to citing standards while I have your time today. So first, I'd like to speak to this same site issue or circumstance. The same site standards are a product of Lane Code and are not found anywhere in state law. The 200-foot square centered on the subject dwelling is a measurement that was proposed and adopted a long time ago. I believe some of the developers here were probably involved in that. So when developers draw their site plans for their forest template dwellings, they often use a 200-foot square. They use those dimensions. And then they say the development is going to be within that development site. And then they say that the dwelling and the well and the septic, they sometimes say this, sometimes they say it, sometimes they show it, sometimes they don't, sometimes it's a combination, are also going to be in this same site. It's kind of a practice that's been going on for a long time here. So a 200-foot square is about an acre. And in the olden days, like the 80s and 90s, you would see in staff reports that an acknowledgement that this was a large development site, and there'd be a statement about why. But now it's just this pretty much the status quo. You do see smaller ones. You don't really see anything larger, but it's pretty common. There are two problems. We see two problems with the use of these same site areas. The first is that it's pretty much a carte blanche path to a type 1 review for two things: accessory structures, buildings, and replacement dwellings. And so type 1 means no notice, no opportunity to comment, no neighbors can be involved. You don't know what happened basically until you might live next door and see something changed. The other issue is that the county doesn't seem to have any authority for this, but they allow replacement dwellings, which are a statutory use, allowed by statute. They require the use of discretion. And the county not only allows them in these same site without notice or the opportunity to comment, but they don't provide notice of decision. So there's a distinction between upfront notice and notice of decision. So even if it is that the case that the county somehow has authority to allow these replacement dwellings in this made-up same site with a ministerial review, it isn't the case that they can do it without providing notice. And there's case law about this. So with regard to fire siting, safety, and design, Landwatch believes that Lane Code is generally consistent with the administrative rules for fire siting, safety, and design, both for roads and for siting of dwellings. Those citations are 660-006, that's the forest rules, 006, and then it's 0029, 0035, and 0040. However, we see our experience over the years, we see three problems. The first is the basis for staff's suggested language that we support, having to do with grading, clearing, thinning of dwelling sites. This is prior to this activity happens prior to an application for the dwelling. So let's make that clear. That's why staff is concerned. It's not happening in conjunction with the building permit. It's happening prior to the application for the dwelling itself. So contrary to past suggestions in this body last year in December, these sites are not really remnants left over from early logging days before there were land use laws, like in the 70s or 60s or something. What we're talking about are sites that have been created much more recently in the last more like 20 years, 15 to 20 years. And
Ms. Siegel, your time is expired.
is it up right now?
It's at 6 minutes. I just,
Oh, okay, well, I'll stop then.
yep. Thank you. Okay, next up, we have our last two sheets. William Dunham, Jim Mann, and David Hemingway, Jim Belknap, and then whoever else I called that wasn't here. So are you Mr. Dunham?
Yes, I am.
Okay, I'll give you 5 minutes at this time, and just state your name and your address.
My name is William Dunham. I live at 763 Muriu Lane here in Eugene, Oregon, 97404. I also live at 90203 Scheffler Road in Elmira, 97437 with my wife. So I'm familiar with a little bit of the development that's going on around the county. I'm going to keep my comments brief. I have some written stuff I wrote down for you all to review. I just asked the commissioners to hold off for a month before you adopt this proposal for the new commissioners to have an idea and their input into this very real problem we have with fire safety. I just got back from Paradise the day after that happened. I have two nephews that lost their homes, and their homes in Paradise are just like in Elmira. Two lanes coming in, you have a fire out there, you're going to have a real similar situation. Hopefully that doesn't happen. Thanks for your time, commissioners. Good day.
Thank you. Okay, we have Jim Mann, followed by David Hemingway, Jim Belknap, and welcome to Mr. Mann.
Commissioners,
Give your
Jim
name
Mann,
and address, and I'll give you 5 minutes.
5025 Saratoga Street, Eugene, Oregon. I've been a land use planner since 1972 by way of introduction. I've been involved with counties in the adoption of the statewide planning goals as well as the state rules. I work for Douglas County and I work for Lane County as one of the primary planners for acknowledgement and then for the development of Chapter 16. I worked with the fire districts when the road standards were developed. Now, looking at the proposal before you to amend Chapter 16, I highly recommend that you adopt it. I think there are a lot of improvements in there that would make it much better, particularly the format. There's a format that we've had in place since 1984. The one that staff has developed is much clearer. The changes primarily comply with the statewide planning goals and the rules. But I do have one concern, and that is with the siting standards that the board took out at the last meeting, and we're going back to the ones that were there before. I support doing that. I have concerns with the siting standards proposed by staff I'm looking back at some of the template dwellings I've done, and I think there are many others in the county that would not meet the step 1 requirements that would automatically kick them into the level 2 review. And I think before you adopt those, you should maybe analyze a year or two of template dwelling approvals. How many of those would automatically be kicked into the level 2 review? My problems with a level 2 review is the highly discretionary kinds of standards that are in place. One of the first standards there is that the siting of the dwelling will have the least impact on nearby or adjacent farm and forest uses. Nearby or adjacent is situational. It can be 50 feet in one area. It could be 1,000 feet in another area. To address that standard, you have to know what the farm and forest uses are on those properties, and then you have to come up with, well, what is the least impact? And that's putting template dwellings into a whole higher level of analysis and review. And then finally, the standard in there that says you cannot use as a factor in siting the dwelling an area that has been cleared, graded, or thinned prior to the application. And prior to is not defined. That can be a year, it can be 10 years, it could be 20 years, it could be 50 years. My concern with that would be is if you're trying to come up with a level site, it may be one that was cleared 20 or 30 years ago. The intention was never to use that as a basis to get a dwelling, but that's where you are. You could not use it. And so just to summarize, I recommend you adopt the code that is before you without the siting standards which have been taken out. Thank you.
Thank you very much. And we are now up to Mr. Hemingway. Is that correct? Okay. David Hemingway, followed by Jim Belknap, and then if Mr. Waterbury is here, we'll take his testimony. But right now, David Hemingway, welcome. Please give your address, and you'll have 5 minutes.
Okay, I currently live at 820 Royaldale in Springfield. It's not normal for me to live inside the city. My family put in about 120 years in the Cottage Grove area on farms and various things down there. I've been a realtor for 50 years and deal mostly with rural properties, a lot of it resource land. Being in business 50 years, it's obvious that I got started before a lot of the rules that are here now were in force. And while I was really upset when Senate Bill 100 passed and thought that everything was going bad, over the years I've seen that it's actually done a lot of good. There is a lot that controlled growth can offer us. On the other hand, as each year goes by, it gets tougher to do your job as a realtor because there's a new reg, a new rule, a new issue. And particularly the siting on F2 has been pretty stable for quite a few years. And those of us that work in that area understand it and know how to work through it. To go to a siting standard that might say it has to be in the best place or the least desirable place for possibly growth of timber or something like that, that's going to mean that you're going to force, if it went through and you were dealing with the planners that have the ultimate or close to the ultimate say over this, you're going to be siting it right next to the access road on the lowest, wettest, least productive piece of property. Well, there's a lot of people out there that would like to enjoy their property. They pay a lot for it, and that should be something that's allowed. When worrying about the forestry issues, that's a big one. And I agree that there should be siting standards in rural residential and farm as well as in timber. But it's a pretty well-known fact that most of the major fires that got out of control happened on federal lands. They may have come on to private land, but they got hot and they got serious on federal lands. So that doesn't mean that the homeowner or the landowner wasn't doing something to prevent the fires so much as maybe the federal governments. Anyway, the bottom line is I urge you to pass this as written and not make it more difficult for people who want to have an opportunity to live in the country and people who already have permits to live in the country but would be cut off because of the changes. Thank you.
Thank you, sir. And next we have Jim Belknap. And we have Norm Waterbury if he's present. If not, I'll ask anybody who hasn't had a chance to speak to hold up their hand, and we can call on you even though you have not signed up. So without further ado, please introduce yourself and where you live, and you'll have 5 minutes.
Thank you. Commissioners, I'm Jim Belknap. My mailing address is P.O. Box 362 in Cottage Grove, 97424. Y'all are saved. I left my glasses and my prepared notes in my pickup truck. So I'm having to just kind of almost fly off the cuff here today. Lydia's laughing.
Jim, I'm sorry. You can use mine.
It's terrible. I would like to think that we are at the end of what has been a long and arduous process. There has been thousands of hours of work that has gone into this. Nobody got everything they wanted by any means. I read yesterday the staff packet that was disseminated and read the emails and some of the letters that had been submitted. And I had some frustration with a couple of things that I read in there. One is there has been an allegation made that this process that we have gone through has not fulfilled goal one, citizen involvement in our land use planning process. And I dispute that. I've been to all of the meetings starting last summer through this fall. Three of you have put up with me previously. The citizenry has been involved. There are people here today that are objecting to bringing this to a conclusion. They weren't here last fall. And I find that to be distressing that they had their opportunity, but now they want to derail what has been a long prepared project. There were a couple of letters that I read in there that were just factually incorrect, and I feel a need to address them. One was from an individual writing on behalf of Land Watch who said that the county failed to enforce provisions in a F2 special use permit requiring the construction of fire suppression systems if a property is outside of a fire district. If you are wanting to build on a piece of land that is outside of a fire district, you have to put in a fire suppression system, a 4,000-gallon holding tank, a pump, hoses. It's complicated. It's expensive. I've done 2 of them for clients over the years. I will tell you that letter is not true. Lane County fulfills the requirements of state statute. They fulfill the requirements of their code. If you build outside of a fire district, you're going to spend $10,000 to $12,000 putting in a fire suppression system. And my irritation with finding that letter there is it attempts to just obfuscate what has been this involved process we've been through. And I don't think it's not appropriate to divert your attention to things like that. We need to keep focused on bringing this to a conclusion. There are applications stacking up at land management right now because hours and hours of staff time are being expended reworking this project. We need to bring this to a conclusion. And my request of you today is to do that, to vote in favor of this ordinance and to let us move on. I think Commissioner Bozevich spoke quite accurately last November when he said, we need to stop the appeals. We need to avoid what will be Measure 49 claims if we change these siting standards and people who have existing special use permits find they can no longer get extensions. And we need to keep faith with people who have processed those applications through every element of the county planning process. And now we face the point that with changing the siting standards, they can't get extensions, and that's totally inappropriate. Just today, Ms. Siegel spoke, and she discussed the 200-foot rectangle in regards to a template test dwelling. They're unrelated. And this is where people interject confusion. The 200-foot box that is applied for a verification of replacement rights is just that. If you want to site a replacement dwelling in an F2 zone piece of land, and you can set that house within a 200-foot by 200-foot box centered on the existing dwelling, that meets the criteria for a same-site dwelling. That's one standard. A template test has nothing to do with that rectangle. The template test has to do with a half-mile by a half-mile rectangle that is overlaid on the subject property, within which you have to identify a certain number of parcels and a certain number of dwellings, and then come back and discuss the soils categories. They're apples and oranges. It's complicated. It's too much to discuss, certainly in 5 minutes. Most people get the land use glaze in about 30 seconds when you have this discussion with them. But let's focus on what has been done for the last 4 years. Let's primarily focus on what's been done the last 6 months. Let's get this voted on and move on. Thank you.
Thank you very much. And let's see, is there anyone that has signed up and not been called? Is there anybody that has?
Waterbury here.
Yeah, is Mr. Waterbury here? No. Is there anybody who has not signed up and does want to speak? Okay, thank you. And we'll get this back to you, Ms. Bell, at some point. Now we need to turn our attention to what we're going to do. We have a bunch of different options. I laid out a couple. One is we have a continued public hearing and get the perspectives of people that were not here today. Another is that we close the public hearing and not have any more public hearings. Another is that we direct staff to do something different than what is in the proposal that the public's had a chance to testify on today. Another would be that we close the hearing and approve the measure as it's presented. And I'll just start this off by saying all these land use issues are very complicated. You know, we're up here, we're talking with people that have multiple advanced degrees, who've taught land use planning, who have been land use planners and have represented people, both applicants and opponents. And it's a very complex set of rules that our state legislature and Land Conservation and Development Commission has put in the form of Oregon administrative rules that we have to follow. Not to mention the fact that we have our own code, and that's what we're talking about here today, making sure it is compliant with the state code. So I'm personally, due to the complexity, I would be open to having another public hearing and having people come in and give more comments on what they like and dislike with this. And also time for the commissioners to formulate questions about how to, you know, pull the code. And so, and change the code or adopt the code. There's going to be plenty of discussion up here. I don't want to cut anyone off, so Commissioner Farr, go ahead.
Thank you, Mr. Chair. You know, it is pretty complex. And really, when you look at it, you try to make it as simple as possible, as easy to understand as possible, and you try to put it into terms that you understand, and in human terms. And, you know, for me, one of the main considerations is always, how do we provide more housing? Now, at face value, you're going to say that's pretty complex when it comes to land use outside the urban growth boundary, because you can't really provide a great deal of housing. However, if we look at what is happening with housing in this state, really we have a responsibility, I believe, to find ways inside of the law and safely to build housing as quickly as possible, not to delay it. We're on the 6th reading of this. We've been working on this for how long now? I can't even remember the beginning of it.
My record, 17th reading. My record.
Actually,
those were the
we
old
went
days.
past 20 on the Florence 2020 plan.
But that being said, we've had a great deal of input on this, and some changes have been made, and I'm prepared to make a motion at this point in time. And I'll then discussion, if I get a second, we can have discussion to the motion. I move to approve the 6th reading, close the public hearing, and approve the ordinance as presented.
Okay, we have a motion to close the public hearing and approve the ordinance. Is there a second?
I will second.
Okay, it's been moved by Commissioner Farr and seconded by Commissioner Bozievich to approve the ordinance and close the public hearing. Do any commissioners want to be recognized on the debate?
Thank you, and I appreciate the opportunity to speak to the motion. We have been at this for a while. We actually, on November 27th, was the day that I proposed this particular language and directed with the vote of 4-1 vote of the board to direct staff to revise the ordinance in accordance with those changes. So it was 4 board members that made that direction. On December 11th, we read that language and voted to reopen the public hearing today. So we have had this language suggested as far back as November, read it a month ago, and we have held a public hearing. In addition, that November 27th date is post the November 6th election date. So the 2 current newly sworn-in commissioners should have been aware of this process going on, and they knew they were going to be seated as commissioners at that time. I have not at any point requested that they recuse themselves. I feel that's something that they have to make that decision on their own. So some of the letters that mention that they were being asked to recuse themselves, I don't know who's asking that. It's certainly not me. Those commissioners are capable of reading the record and making decisions and deciding if they've had enough time to make a decision. I'd like to kind of review a little history here. We set out about this with board direction to accept a grant from the state to modernize our code. At the time we accepted that, there was direction from a majority of the board to develop that new code in a policy-neutral way, not to make it more permissive or more restrictive, was the attempt we were trying to make. Unfortunately, what happened in moving back to the OAR wording was it accidentally became more restrictive and possibly set us up for lawsuits under Measure 49. So the move back to old language is an attempt to hold to that original board direction to keep the code change policy neutral and to also make sure we weren't going to waste county resources defending ourselves against Measure 49 claims in the future. Resources that could be better spent, possibly looking at maybe new citing standards for EFU and RR or a new fire code. But if we spend our time in court defending Measure 49 claims, our staff time will get eaten up. And that's what I'm concerned about. So I think, I'm hoping that our new members have had a chance to study the record. And I'm hoping that they're willing to participate in this vote today, and I'm hoping we can move this forward. It has been going on a long time. This is the last chapter of the modernization project, and it would be great to move past this And then we can go back and surgically look at pieces that folks want to look at. If they want to change stuff to make it more restrictive or to make fire safety improvements, that's a different discussion. But I think what we're doing here is getting the code 16 in compliance with chapters 13 and other chapters where the format's all been changed, there are references that are at stake here. We really need to close this project up.
Okay, any further comments?
You go first, I'll go.
Okay, Commissioner Bernie?
You all have no idea how much you had figured this out, or this group had figured this out and resolved this prior to today. As someone who's developed in rural areas, multifamily housing 40 years ago, I can tell you that even the 1984 document was more onerous than documents I've had to develop under. Having said that, I do not accept Commissioner Bozevic's telling me what my priorities are and aren't in reviewing several thousand pages of documents so that I can make an intelligent decision. I believe that's incumbent upon me. I have been, by the way, for those of you, all of you know this, but for the record, we are talking about well over over 1,000 pages and documents as we are trying to bring ourselves, I'll speak for myself, as a new commissioner, 8 days into the job, to be on top of everything. And in terms of being responsible, I have had, by the way, I want to share from many quarters, and I don't know where it's come from. I never suggested any source, that I recuse myself. Would love to be able to do that with a clear conscience. Can't. I also don't appreciate and am respectful of people who have been investing for months and years laboriously in a process that I wish had come to completion in 2018. It did not. But I respect your time. I hope you will respect my position that I need another month to understand these issues. I don't need a month to be lobbied by either side. I don't need a month to have someone else make up my mind for me, but I would very much like to have more time because this is a significant issue. I don't know which way this commission will go, but I wanted to weigh in only because I just reject the notion that someone else is going to box me in and tell me what I am supposed to be prepared for and what I am not within what time frame.
Okay, end of first round. Go ahead, Commissioner.
I had a question for staff, but also a general discussion item is I've been following these readings for some time. Understand that there's been a lot of time and energy and finances put into this. And I know that everybody, in many cases, want a resolution for, in the most contentious issue that I see is the siting standards, it seems. I'm willing to support moving forward in adopting the code, but with the understanding that the commission come back and direct staff to talk further about the specific siting standards issues that we've been hearing that seem to be the most contentious issue. That's where I'm at right now. But the question I had for staff specifically was what Mr. Leach brought up regarding extension of permits. I would like to know, how are those permits, are they grandfathered in? And there's always going to be people with extensions of permits, no matter when we discuss updating code. It will be a perpetual issue. And some people will be affected and others will not. It doesn't mean that we need to stop for our work in order to update that code. However, I would like a little staff input on his particular testimony.
So the timeline extension requirements come out of the Oregon Administrative Rules, and those specify that if the criteria have changed, then we're not permitted to issue timeline extensions. There's been some other concerns raised regarding timeline extensions with Land Code Chapter 14 that is on appeal before LUBA. Our intention is to continue to process timeline extensions. Notwithstanding any changes to the citing standards, which again, those have been replaced with the currently adopted standards, so we wouldn't anticipate any issues with that regard. So we will continue to process timeline extensions unless we receive some sort of direction from the Land Use Board of Appeals or another legal authority that indicate that that's not compliant with state law.
So just to clarify that, thanks, Ms. Bell. Currently, that is our procedure in the Land Management Division, is that when people apply for the extensions for a year, we approve them. We've been doing that. It's our intent to continue to do that because that's what we believe, and our legal counsel has told us that that's what we believe is legally correct. So when Ms. Bell mentions that until some other time, if the Board of County Commissioners, through a code update or through the land use appeals process, the Land Use Board of Appeals said that's not legally consistent with the Oregon Revised Statutes, if there's some case law that gives us different information, then we would change that because we follow land use case law. That's what we try and do. So just to clarify, hopefully that was helpful.
So let me just make a few comments on this. I do believe this is a very complicated area, and I do think that it would be good to put this out for another public hearing, give an opportunity for commissioners to review the materials, give an opportunity for the public to, again, tell us what they want us to do or not do. My view is that when it's gone on, into the new year, that there are reasons to make sure that people are heard and make sure. I myself am very concerned about the fire issue, and I know we've had people say, "Well, let's bring that up later." Well, why not bring it up now? That's, I guess, my response is that I don't recall that anybody took a blood oath that they won't make changes in this code because it hasn't been unanimous or there's no policy implications. Obviously, if you strengthen the fire standards in this code before we adopt it, to me, that would be in order to the benefit of the public this summer, now, soon. So I like the idea of having more process here. And I haven't really heard an argument other than it means we would have more readings. I haven't really heard an argument other than we've spent, or I should say the prior board spent a lot of time on it. So I just feel like, why not? And so I would just say I'm against closing the public hearing and saying, let's adopt it. That's the motion that's pending. That's what we're debating. So I would just say I would be against that motion. Did you want to add something?
If you don't mind, Chair Sorensen, from the perspective of the planning director and the division manager, if I might say this is actually my last time I will be before this body in that capacity. I think most of you know that I'm moving on to a different organization, but the perspective from the planning director is that there is an advantage to doing what I think Vice Chair Buck was suggesting, which is approving the code that you have before you today. And then directing staff, which if 3 of you say, yes, this is what we want you to do, you can direct staff, and we would utilize our brilliant Keir Miller to come back and talk to you about the fire citing standards. He had a lot to do with the details of why they were written the way that they were. He's the one who really got us the FireWise program, the federal FireWise program that the Land Management Division administers. He has a lot of experience and background that I think would be useful for the board to hear. And as some people talked about, the siting standards in the past were created with, planners are pretty smart, I like to think, but they were created with a larger group of people, right? We go all task forcey in planning so that we get feedback from, the fire districts and the people who are doing the laws. If the board is interested in looking at the standards, the humble planning director's opinion is, if you want to approve the code today, we can move all that good work forward. That's what my personal opinion would be. We can move that good work forward, and then you can direct us to focus, and this would be Keir, because I'm leaving, but you can direct the planning staff to focus to come before you and just have a conversation on the fire standards. I think the conversation would be more robust if the board wasn't also discussing guest houses and the format of the code and all of these other things that have been vetted. Now, that's, again, I'll stop talking, but that's just my opinion. And you said you hadn't heard a reason to, why wouldn't we just keep the hearing open and wait until July? Well, there's Measure 56 notice, which you're familiar with, which we've given already. And I don't know if you know the cost of it, but it's, tens of thousands of dollars for the county to do a Measure 56 notice, because we have to notify every property owner who owns property that we're adopting standards that might impact their property values. And as Mr. Belknap, I think, was referencing, or actually it was Mr. Evans, some of the language in land use is by statute pretty squishy. So legal counsel would want to discuss that with us if we're making changes that would be different than what we've been talking about in the last few years. I'm just putting that out there as another thing for the board to consider. That's all.
Mr. Chair, I've not yet spoken to my motion.
Yeah, go ahead.
Thank you. And, I'm glad I didn't speak to my motion until after you spoke, Ms. McKinney, because with your very humble opinion, I think you very eloquently stated a prescribed path. Staff, very talented staff sitting in this room have been working for a long time on this, and I am anxious to get staff back to other projects, back to facilitating the building of housing in Lane County in a legal, prescribed, safe fashion. And as we move forward, if we were to pass this motion today, that would give staff an opportunity to perhaps go back to some other work, unless you become so embedded in this that it's where you want to stay for a long, long time to come. I don't see that on your face. And also you pointed out that Mr. Miller has a great background in fire suppression regulations. Is that a good way to look at it? No. And which we could go for quite some time adopting more and more safe regulations on an existing code. And in the meantime, we heard testimony that permits are stacking up. I've heard testimony outside of this room that permits are stacking up, that people are just waiting and waiting and waiting to get approval to build a home, to whether it be their dream home or their modest caretaker home or their farm help home, whatever it may be. So I'm anxious to get moving forward with that. So I think if we were to pass this ordinance today, move forward, close the public hearing, pass the ordinance today, and then move forward with some other considerations surrounding fire safety standards, then that seems like an appropriate direction to go. So thank you very much for your Uriah Heepian recommendation. For those of you who don't know, Uriah Heep, he was a very humble servant in Dickens.
Very good. Additional comments from commissioners? Commissioner Burney?
Wait, did you want to go? Oh, go ahead. I do ask questions I don't know the answer of. Due to finite staff resources, is a preoccupation with this, in fact, as Commissioner Farr suggested, creating applications for moving forward with housing that are stacking up?
I'll actually allow the planning director to take that question.
Thank you. So the Land Management Division is primarily fee-supported. So we take in money from our building permit program and from our planning permit program, and statutorily, those monies have to be spent on those functions. So we have a limited staff, and we're very careful and smart about how we budget for people. We try and keep a little money in reserve so the economy goes up and down. It's a volatile business. So the question is, do having staff work on this result in the planning application stacking up? So I like answers like this, yes and no. The reason that I say that is because we have wonderful staff, as I think Commissioner Farr mentioned. We have really great staff, and we have people who are specifically working on long-range planning. And Ms. Bell is one of those people who this is the work that she is working on. We have other awesome planners who are at their desks right now, probably watching us because they're interested in it. But they're working on those permits that you're talking about. So they're split apart. However, we work as a team, and Ms. Bell helps out the current planners when there are applications stacking up. This isn't our busiest time of year, but we're always popular. There's always people who want land use applications, building permits, electrical permits. We do all kinds of fun stuff. So there is, in my mind, again, from the perspective of your exiting director, if we continued to work on this and had more public hearings and, you know, the director and the planning director spends time with legal counsel and we continue to discuss, do we need a 56 notice? Do we need this? And Ms. Bell would continue because she's really the one who's got her big brain focused on this. It would have some impact on our ability to issue permits. It's not that somebody in the field is going to be able to come to you and say, Commissioner Burney, that land management division, they're working on this 16, and that's the reason I don't have my building permit. I can almost guarantee you that that will never be a true statement.
Okay. And thank you, and I beg your forgiveness, because I know everything we do has implications for staff, and the last thing I want to get in an MO of is creating more demands when they don't need to be. Someone made a statement, my experience, which is limited, there's always grandfather clauses. Did I hear someone say that if the new ordinance were adopted or this, that people wouldn't be able to be grandfathered in, that are now have permits?
That was a concern with the old, the previous code. So because what's before you today has the forest siting standards that are currently in our code, we don't believe that that's an issue.
And if it were changed?
Then that's a conversation that we would have under the discussion, a bigger conversation about what are the impacts of changing the fire siting standards, and have some conversation about that.
Well, as I was trying to keep up well before being here, my understanding was you did have recommendations that were dismissed, right, and went back. But if those recommendations had been accepted, would people still be able to be grandfathered in that had existing applications?
That's a legal question, and some people think yes, and some people think no. And again, that's where we live in land use. There's a term that I think is a legal term. Reasonable people can differ. And so, right, people can come to different conclusions. And perhaps legal counsel Clark would like to take, he doesn't like it when I talk about the legal stuff, so.
I do, actually. But no, I think the general easy answer is applicants are entitled to the substantive rules that are on the books when they file their application.
Thank you.
Procedural is a different issue, but so generally, the answer would be yeah.
Thank you.
Grandfather.
Does anyone else want to say anything? Okay, I just will put a pitch in that if we went back to what staff proposed, then we would be finishing this project, right? Your original language that you propose,
Well, if we go.
this ordinance. You proposed an ordinance.
Yes.
You proposed an ordinance. We had a public hearing on it. It was changed by vote of the board to the substantive matters that we're bringing up today. We've got a motion to approve it, cut the public hearing off, and adopt the ordinance, okay? We could also just go back to the other one, right? The proposed one.
Not without subsequent readings.
Not without subsequent readings.
Correct.
Right, yeah.
Okay. All right. Okay. Well, then, I think we're ready to vote unless there's anything further on this. So it's been moved to approve. This is an ordinance, so I'll ask our county administrator to poll the board on the motion.
For the record, moved by Farr, seconded by Bozovich.
Yep.
Commissioner Bozovich?
Aye.
Commissioner Burney?
Nay.
Commissioner Buck?
Aye.
Commissioner Farr?
Aye.
Commissioner Sorensen?
No, and the motion does carry. And what is the vote, Mr. Mokrzywski?
It's 3-2 with Bernie and Sorensen opposed.
Thank you very much. Okay.
Chair, just for
Yeah.
a moment. At this point, is this the right time where we can direct staff perhaps to move forward with the more discussion on the siting standards and come back?
Probably best to bring that under assignments, future
We
assignments.
can do that.
Yeah.
Whatever works
Yeah.
for staff.
Okay, so we now, thank you very much. We'll let you guys move your stuff away, call up Mr. Dingle, our third Steve of the day at least. This is item 7C. This is the first reading and setting the second reading and public hearing on ordinance 1901. The matter of amending Lane Code, Chapter 4, to add limitations on general bond issues for Lane County Courthouse Replacement Project, Lane Code 4.4800 to 4.820. With us to discuss this issue is Stephen Dingle, Lane County Council. And as we mentioned earlier about the procedures of the board on ordinances, we have typically a first reading, then there's a 2-week period, and then there's a second reading and public hearing. And so in this instance, the board's had quite a bit of briefing on this, but I'll call on Mr. Dingle first, and then Mr. Mokrzywski, and then we'll see if there's a motion to actually more formalize this. So at first, I'll call on Mr. Dingle, then Mr. Mokrzywski, and then we'll have the board make a motion if it so wishes.
Thank you. Chair Sorensen, members of the board. Yes, the ordinance rules are set out in the charter. It's actually 13 days between readings. This is an ordinance that is obviously related to the courthouse. And I think it's pretty self-explanatory, but I think with just a little bit of explanation of the background, this is really to provide assurance, I think, to the voters. You'll notice that the way, I think from my perspective, the key provision is the last one, which is 4820, which makes it clear that the only way that those bonds will be issued is if all of those things occur. In other words, the legislature approves the matching funds, the governor signs off on the matching funds, the voters approve it, and then you, after a public hearing, authorize the issuance of the bonds. That's really what this is. I can tell you that staff met with our bond counsel. For those of you members that aren't familiar with this, it's a very, very technical area of the law under Oregon law. So we hire specialized bond counsel to review it to make sure that all the things that we say and put out there about the bonds are absolutely accurate. And I can tell you that they have approved this particular language, that draft language in 4.800. That's all I have unless the board has or an individual member has a specific question.
Okay, any questions from commissioners on the, for the legal counsel? Okay, Mr. Mokrzywski.
Thank you, Mr. Chair. What I was going to do is just provide an update on some of the questions that were asked last week. Okay, here we go. So the first item, there was some clarification, I think, desired regarding the difference between a voter's pamphlet and a voter information brochure. So I have 4 slides here. Can you just toss me the, Jeff, thanks. So this is just briefly, a voter's pamphlet is governed by ORS 251.305-991 and Lane County Code. I'm going to pass out here the Lane County Code hard copy. This can be found on our website, so if you want to see those.
One copy.
I just have one copy right now. You can find it online as well, but if you're interested in that. And then I have copies of an example. Do you want to pass these out? An example of a voter pamphlet. This was used in the 2015 special election for the jail levy, and then a voter information, actually other way around, the voter information guide was used for, the information guide was used for the jail levy, and the voter pamphlet was used for the vehicle registration fee in 2015. So the voters pamphlet, governed by ORS and Lane Code, distributed to all Lane County households. The costs are statutorily shared between each district based on who has, and you'll see in the voter pamphlet there, you have school districts, elections, and fire district elections, and so the total cost of the pamphlet is distributed between the various districts that are on that ballot. There is an opportunity for arguments for ballot measures as well as for candidates, and you'll see in the voter pamphlet, candidate information is included. The voters pamphlet was most recently used by Lane County for the 2015 vehicle registration fee, which you have is being passed there. We put together as objectively as possible as we could to sort of present to you pros and cons of each of these. For a voters pamphlet, the pros could be that it's a recognized format that voters are familiar with. The costs are shared with special districts. That also can be a con in that while it would decrease the total cost to Lane County, it also increases the cost for other districts that may not be anticipating that cost. There is another pros, there is an opportunity for arguments and for candidates. The cons could be that special districts are not anticipating the expense, a significant amount of additional staff requirements for the county clerk to review all of those. So all the candidates that would include information there, they'd have to review it for accuracy and for timing. Staffing requirements and timing of explanatory statement committee. Under the county code, there's a requirement that we put together a committee of pro, con, and neutral individuals. It has the potential to increase risk of errors for official ballot pages, and it wouldn't focus specifically on Lane County's measure. It would be for all the measures on the ballot at that time. A voter information brochure, which you also have an example of in front of you, again, was used for the jail levy in 2013 and 2017, is also distributed to all Lane County households. The costs are paid fully by Lane County, so the total cost, I believe, we estimated the cost of a voter's pamphlet, which is the statutory version, at $25,000 and change in 2015. In 2017, the voter information brochure was approximately $30,690. So the cost for a voter information brochure borne exclusively by Lane County, there would be an opportunity for arguments, but not for candidates in a voter information brochure. Most recently, again, we used that for the jail levy in 13 and 17. Pros include similar in format to the voter pamphlet. It emphasizes Lane County's measure exclusively. There's an opportunity for arguments. It limits the additional staff requirements for the county clerk because it's just on that measure, not all the candidates. There's no unanticipated cost for the special districts. The cons are it's more expensive to Lane County than the voter pamphlet, and there's no opportunity for other candidates that may be on the ballot. So that's it on that. I have responses to the other questions that were asked, but if you have comments or questions, one of the things that we're looking for from the board is some direction. If you want to do either of those or none, and then if you want to pursue one, which one?
Okay, Mr. Mokryski, I'm kind of thinking out loud here. Do you want to entertain some questions first, or would you rather go
I can
ahead
go on
with
to the other items. I don't know if that there will be as many questions with the other items. This is the one we need specific. I'm thinking this one and a voter survey.
Okay.
Are two things we're going to need direction from the board on. I also have some information about a voter survey.
Okay, well, let me just start this out, and I'll ask some questions and invite the commissioners to ask questions as well. The first question I have is, do you have any information on the cost of a voter's pamphlet versus a cost of a information sheet?
So a voter's pamphlet in 2015 for the vehicle registration fee was approximately $25,671. Lane County, that was the total cost of the voter pamphlet. Lane County's share in 2015 was $8,195.
For the voter's pamphlet?
The voter pamphlet. So that's an example of, the costs are relatively equal because most of the cost is in mailing.
Yeah.
And you're mailing to all of Lane County households, so
Right.
it's going to be somewhere between 20 to 30,000 ballpark. The voter information brochure in 2017 for the jail levy renewal was $30,690, and that was borne exclusively by Lane County.
Okay, so about 8,000 for the county's portion of a voter pamphlet, about 30,000 paid entirely by the county for a voter information brochure.
Right.
Second question, with regard to the voter information brochure, is there any difficulty, and maybe this is a Steve Dingle question, is there any difficulty in allowing people who are opposed to it to put an argument in the information sheet? They can put an argument in?
Yes,
How do we pick who gets to put an argument in?
They pay.
they pay, yeah, I was gonna say,
They
that
pay.
I would say this in general terms. The difference between the voter information brochure and the voter's pamphlet is that the voter's pamphlet is extremely structured by statute.
Yeah.
There's all kinds of word limitations, all those
It's a
sorts of
county
things.
voter's pamphlet set out in a state statute what a county voter's pamphlet is.
I think the county really has much more flexibility with the brochure in terms of how you structure it, what goes in it, what doesn't go in it.
Right.
It's really
Okay.
it's really up to the board and who pays.
Yeah, right. I personally favor a county voter's pamphlet, and let me just tell you why. It's actually refreshing to me to hear that it costs the county less money to do a voter's pamphlet. But here's why. I think commissioners have three jobs up here. They have the job of helping to run the county government. And as big a job as that is, that's only 1/3 of their job. It's a huge job. But a second part of their job is to deal with their constituents, their constituent problems, and to be the one and only paid person that they elect to help constituents with government problems across the board. International governments, national governments, state governments, county governments, city governments, any government. And then there's a big 1/3 of the job where I think this comes in, and that is we have a leadership role. Our decision of whether to offer a county voter's pamphlet that affects the candidates for many, many other public offices, which would otherwise not have a voter's pamphlet unless Lane County used its power as a issuer of a county voter's pamphlet, it would mean that all the other matters in our democracy throughout our entire county, there would be no opportunity for a voter's pamphlet. So I kind of see this as not just a financial, that it's cheaper for us to do it, but that it also achieves a leadership function. But that is just my view. Before I ask more questions, I'll just ask the board members if they want to ask questions. Okay, Commissioner Farr.
Thank you, Mr. Chair. And I understand that the voters pamphlet, should we go with that, we incur costs for other taxing bodies or other jurisdictions.
Yeah, that's correct. I just was asking Mr. Dingle if the board, if the county had the ability to pay for the entire cost, if that's something that, my opinion is, you're talking about anywhere from $10,000 to $30,000 on a $150 million plus bond measure. I wouldn't let $10,000 to $30,000 be a major factor in your decision. So I think ultimately you should select the option that you feel the most confident about. And then if you're concerned about the special, if that's the option you like, voter pamphlet, you're concerned about the special districts, we certainly could explore if you wanted the county to pay for the whole thing, if that's a possibility under the law. So it doesn't negatively impact the special district.
And the reason I ask that question is a fourth responsibility that we have perhaps, and that is to make certain that the other jurisdictions inside of our jurisdiction aren't burdened by our actions. And if it's insignificant, or if we can cover the cost of that, I see the value of a voter's pamphlet, absolutely, because you get if you receive this in the mail, you get to read about our levy. If you get this in the mail, you get to see pictures of Joe Berney, or whoever's picture happens to be in there.
Thanks a lot.
That's tongue in cheek, absolutely. You get to see a lot more than just our one issue, and I like that because Commissioner Sorensen's second responsibility that he outlined. We are, I think it was the second, we're responsible for let's see, giving information to the people.
Yeah, leadership.
Leadership, thank you, that was the term you used. So that being said, I prefer the voters pamphlet, and you know, $5,000 difference isn't that big of a difference. However, Mr. Mokryski, I would probably explore paying for the other jurisdictions. I know you heard that, even though you were, because I said it 3 times now. So, okay, so thank you.
Any other, Commissioner Bozievich?
Thank you. I think there are a couple other responsibilities we have. One of them is to make efficient use of our resources and staff, which are limited. And the informational that's specific to our measure does provide the opportunity for pro-con arguments on our measure, but it's the most efficient use of our election staff. If we have a full-blown voters pamphlet, there's a huge staff impact in elections. Second is, I believe we shouldn't be passing on unfunded mandates. We have a legislative priority written in our policies right now that we basically take a stance against unfunded mandates. We decide to put together a voters pamphlet. We've passed on an unfunded mandate to all of our special districts. In addition, there was basically an unfunded mandate passed on to Lane County a couple of years ago, a motor voter. We have not received the funding from the state to make up for the additional voters, nowhere close. So we're already running behind in elections. So if we're going to add a voters pamphlet where they also have to follow all that statutory requirement and collect information on candidates, get their pictures, make sure their pictures meet all the requirements of the Secretary of State's office, you know, like they don't have a lapel pin on with a flag, little things like that. That's a huge staff load on an elections division that I want them concentrated on running a fair election. I don't want them concentrated on putting out a voters pamphlet. So for me, it may be a little bit more expensive for the county to go to an informational pamphlet, but it offers what we need, which is information on this measure if we choose to place it on the ballot this time, because we got to talk about polling first. And also, if we really want to have full-blown voters pamphlets, we need to talk to the state about how they're funding elections, particularly how they've lagged in their funding of the motor voter, which there was a promise that they were going to increase support to elections divisions. So if we really want to get back to having full-blown voters pamphlets for every election, not just this one, then there's a whole nother conversation we ought to be having with the legislature and the state this spring. I don't think we should be dumping that on special districts and just doing it willy-nilly. I think really, the difference between $10,000 and $30,000 because we have to foot it on our own. The biggest impact to me is the difference between, how many hours of actual elections office staff time we're taking up.
Okay, any other comments before we move to the formal matter of putting the measure up for a public hearing next 2 weeks?
So I have a couple other responses to questions asked last week.
Why don't you answer those questions, and then I'll call on Commissioner Burney.
Okay, so there's a question about the status of the law library in the new building. The law library is currently in the program from the scoping study, so that is included, space for the law library to move over to the new courthouse. There are currently efforts underway to include the law library as a reimbursable expense under the Oregon Courthouse Capital Construction Improvement Fund. OJD, the Oregon Judicial Department, has thus far been reluctant to invest OCCIF dollars into law libraries, despite the fact that they are mandated service under state law. So that's sort of a potential in the future. It is law library is included in the scoping study, but it is not reimbursable as of yet. We discussed the voter pamphlet cost. There's a question about will there be a sky bridge between the courthouse and the PSB. Is that an option? That is not currently in the project scope. It would be in addition to the current project scope and cost. The scoping study envisioned a potential mid-block crossing of Pearl Street from the Public Service Building to the new Sheriff's Office, entrance as a more cost-effective solution. We did explore Skybridge in 2016 in our joint city-county work, but it was decided that renovating, and that would have been if we would have left some of the sheriff and DA's office in a renovated old courthouse as well as building a new. It was determined that renovating the existing courthouse to serve those functions wasn't practical nor cost-effective. So that's something that the board could decide at a future date if that was something you wanted to add back into the project. We need to identify funding or see how that could be fit into the project scope. I'm going to come back to polling because we'll need direction on that. And then there's a question about, are there any national survey data? Is there any national survey data about what court patrons like or dislike about the court? There is National Center for State Courts conducts a comprehensive public opinion survey annually. And we have the 2017, 2018 public opinion surveys around the state of courts and public opinion around court facilities. So I'm going to send all this. I'm going to have Jeff Kincaid from County Administration send this to the commissioners in an email, but I just wanted to respond on the record for those. And so you'll get links to those two surveys to consider. And then there will be a few other brief updates in here that are sort of routine. Finally, regarding polling, there's been discussion. You heard testimony this morning under public comment regarding polling. There is no plan to do additional polling. We did a survey in April of 2018 regarding voter sentiment around court functions, and then regarding price points that we were reported back to you last week. So there is not currently a plan. There's been a concern about the amount of time that is necessary for a poll to happen before you need to make a decision, either February 12th or February 26th, I think is the absolute drop dead date. Developing a poll, vetting it for scientific requirements, conducting the poll and then receiving the report. Staff has commented that our feeling is that it would be more feasible for an advocacy group to consider doing polling between March and May. I understand that the concern from commissioners is if your decision is contingent upon additional information, having an advocacy group do that after you make a decision doesn't meet that requirement. So what I would tell you is, here are the constraints with a poll. Typically, it takes about 1 to 4, we build in about 1 to 4 weeks, depending on the availability of the pollster. So it sort of depends on, what polling firm do you want to use? Is that polling firm going to be available right away, or do we have to wait? Do they have some other poll there? So we kind of have a 1 to 4 week period in there that that it could take just to mobilize the polling firm, depending on what other work they have. And then drafting of questions, it typically can take from 3 to 6 weeks, depending on how much public process you want to involve. So if you didn't want a lot of public process, you just want to ask the same questions we asked before, you just want updated numbers, that could be shrunk. The in-field work oftentimes can take a couple weeks. If you're trying to get anywhere from 300 to 600 registered voters or active voters. So a couple weeks for the in-field work, and then to get the results, typically 2 to 3 days after the field work is done. So what isn't going to change much is the 2 weeks to do the polling, and then the 2 to 3 days after the field work for them to pull it together. If we could shorten up the time frame, so we typically estimate 6.5 to 12.5 weeks, depending on the time for question development in the public process. If you can cut out some of those things, you could probably speed that process up. So we'll seek direction from the board. If that's a critical matter for you, we'd want to know, do you have a recommended polling firm you would want? Do you want us to use the same firm we used before in Elsinger Report, or a different firm? Do you want us to do the same questions we did before, or different questions? Depending on the answers to those questions, it could take shorter or longer. But the two matters, in addition to, if you're going to move this forward to a second reading, we need direction on our voters pamphlet versus voter information brochure and a poll.
Okay, so we can have some questions and comments further on this matter and others. Go ahead.
Oh, my question was actually answered.
Oh.
So I have comments as we comment, but I'm good.
Okay. I'll just say my own view is that, and this is based somewhat on the fact that I've been a campaign manager for a successful candidate for Congress, is that you can get a poll done a lot quicker than 12 weeks. And secondly, the 5 commissioners have all won elections. I don't know if we've all used polling, but I don't recall a 12-week, 12-week period. I just think that's not, that is, in my view, that is a really long period of time, Anyway, but I am in favor of the polling and doing the polling prior to the board's decision, if at all possible. Regarding the board decision today, I think we should move ahead and, at least as of today, move the reading of it and move the public hearing and take public testimony. And I also think we need a timeline that we can refer to if we're going to move with the voters pamphlet. Well, either way, whether we move with the voters pamphlet or not, we still need a timeline on when things have to get done. So I'll just state my summary of my wish list, and then I'll invite the commissioners to state theirs. So my wish list would be, number one, that we have the reading today and we pass it and we have the public hearing in 2 weeks. Number two, that we have additional polling and that we try to ask more questions, different questions, using language that we think will be thrown up against us. The most expensive courthouse in Lane County history, $250 million. Some numbers that have been used in the community that might well be used against us. And I mentioned the voters pamphlet as opposed to a voter information sheet. So I'll invite the commissioners to give their views so that it'll assist staff in the next step. And then when we finish that, we will have a formal motion for the approval. Yep.
I fully expect to be in the minority again, but just a correction, and that is that I've never polled. My opponent polled, and I used the results of those polls, but I am not one that feels an additional poll is necessary to make a commitment one way or the other.
Okay. What about the rest of it? I said, what about the rest of the things that he wanted to feedback on, the voters pamphlet and what was the third thing?
Voter pamphlet versus voter
Yeah.
information brochure.
Yeah, and then the third one was actually moving it forward today.
Moving it forward today, yes. Voters pamphlet versus brochure, I'm still listening.
Okay.
So, one, I want to be clear, what we're moving forward today is an ordinance about restricting how the bonds are issued, not the actual ballot measure. So we can move that forward, hold the hearing and adopt that ordinance and have it sit till 2020 if we wait to do a bond vote in 2020. It just, that language will be sitting in code for whenever we do a courthouse bond. So I just want to be clear, it's a standalone action that doesn't affect whether we call for a May vote.
That, Chair Sorensen, Commissioner Bozovich, that's correct. It doesn't have any time limitation on it. It doesn't list the 2019 legislature, the 2020 legislature, the May 2019 election. No.
I just want to make sure that was clear, that we're not deciding to place this on the May ballot today, or to set up a hearing to place it on the May ballot. Today's ordinance is about the limitations around that. If we were to get, a successful vote of the electorate to support a bond measure for the county's share, this sets about the fact that we can't actually issue those bonds until we have certain things in place, successful, state matching funds signed by the governor, all that good stuff. And then we hold another hearing. So that's, it's just, I want to just make sure that's very clear. And I very much support moving the first reading and setting up the hearing on that. Secondly, yes, you can get a survey out in a hurry, and particularly around candidates, because those surveys are pretty standard. If you want to do a survey around your candidate's weaknesses and messaging, that's a lot more to set up. You know, if you want to just do a straight head up, you know, so-and-so against so-and-so, name recognition, those things, those are standard surveys. And depending on how much you want to pay on how quickly they actually do the field work and how many people they throw at it, you can get them done in a week. But if we're going to, you know, if you're going to do any changes to the current survey work and start talking about trying to test messaging and all that stuff, there's going to be a lot of back and forth with consultants about, is the language, you know, is tilted to get us, you know, you got to be careful about how you ask the questions. There is a back and forth that goes on, and I think you're talking weeks before you even get in the field, and unless we're ready to pay premiums and all that, and plus you're talking, as you get into messaging surveys and expanding surveys, you get a lot of people that hang up with non-completion of the survey. The longer the survey, you know, if you get a 2-question survey, you know, name recognition, heads up, you know, a head up, you know, do you support so-and-so or so-and-so, less than 5-minute, 3-question survey, you can get the results back in a hurry because you're going to get people to stay on the phone for that. Once you get to the 10, 20-question survey, you're not going to be able to get completions. So that's part of the problem as we go there. So my experience in running campaigns and also running for office is, yes, you can get a quicker survey than 6 weeks, possibly, but you're going to get a much less robust survey. We do have a survey, so it's kind of like, is it enough for us to make a decision on? I would like to see stronger numbers. We had close to 66% when you add the probables and likely yes on the first jail levy. They had, quote, 58% in their method of taking only half of the likelies. As I went and looked back just to try and refresh my memory, so we're not where we were there. But there was a lot more in the news then and a lot more awareness of the whole issue around jail capacity and the impact it's had on the community. I mean, at that point, I think we had had people released from jail and rearrested within 45 minutes for robbing a bank, you know, that had been headline news. So there's a little bit difference in education factors. So, you know, is the education going to be helpful or against us? We're just going to have to probably make a judgment call without additional polling. And I'll reiterate, I kind of feel that we're better off with a voter information pamphlet rather than a full-blown voters pamphlet in accordance with state law.
Okay.
I'm not a polling expert, so I'm not going to pretend to know much about polling. I do know that we had one, and it was fairly thorough, and could understand why an advocacy group might be better for that in the long-term course of this going on the ballot. I'm definitely in favor of moving this forward today. I also believe a full-blown voters pamphlet is something that is a valuable educational tool for voters, and in comparison to the size of the financing that we're looking for the courthouse, it's a very small price to pay in order to get the education that we need out for people to make an educated vote. Clearly from the polling that was done, it needs voter education in order to be successful. So if other commissioners support that, I do.
You know, I'm not sold on the effectiveness of a voters pamphlet. You know, in the general election 2018, Rich Cunningham got 11,000 votes, wasn't in the voters pamphlet. Mark Herbert got 8,000 votes, was in the voters pamphlet. So did that make any difference? I don't know. But that being said, Ms. Mokrahajski, if we would consider eliminating the unfunded mandate and paying for the entire cost of the voters pamphlet, then I would be in favor of the voters pamphlet. Other than that, I am a little bit concerned about causing smaller jurisdictions or smaller taxing districts to have to pay what may be an inordinate amount of their budget. So voters pamphlet, yes, if we're going to pay for the whole thing. Otherwise, the levy information just in the pamphlet. So.
Chair Sorensen, Commissioner Farr, just talking on our side there, I don't think we know of any specific answer to that question. The qualified answer is, I can't think of a reason why we couldn't. However, I told Mr. Mokrahajski, if it's the board's direction, I will contact the Secretary of State's office and their elections division and ask them if they believe there's any limitation on the county picking, at least what I hear, perhaps there's going to be direction from the board to find out whether or not the county can pick up the special districts portion of the voters pamphlet, so there isn't any unfunded mandate. And apparently Mr. Rickoff knows.
That is a good question, and I do not have an answer to that. I do know that there are 64 districts in Lane County, and that all would have to be offered the opportunity to participate in the voters pamphlet. All 64 districts that have an election, anybody who is a candidate, and of course, that would then be considered free advertising, so you can guess how folks would respond to having a voters pamphlet paid for. And please do recognize that any mistake that a candidate or a district might make in their material, you will own as part of the voters pamphlet. Just as when the state voters pamphlet goes out, if there's mistakes in that, it's, often through the submission, but it's the state's responsibility and obligation to proof and make sure that all of the materials are perfect. That then would be, of course, the county's responsibility. And so the chance for error is very significant. It has an identical timeline to the election season. So the exact same 5 full-time staff and 150 part-time staff that will be preparing and managing the over 200 different ballot styles will also be responsible for preparing and managing the voters pamphlet, regardless of size, depth, and issue. So the voters pamphlet is a significant obligation that you would bear. So that's
short
part of the
a burden on our elections division.
And we can handle that. That is what we've signed up for. Sure. It's the chance of materials being incorrect and then becoming an election issue, whether it's our mistake or not. If we have not caught that and fixed that, of course, it will be the county's burden.
That leads me toward the pamphlet. Thank you.
Okay, so have you received enough feedback or want any more feedback?
Sort of.
Sort of.
I heard 2 strong supports for a voters pamphlet. And then I heard Commissioner Farr say, well, if we can pay for the special district, and so I guess I didn't hear Commissioner Burney was still listening to arguments, so I heard 1 strong on the poll, and I didn't get that's what we need here I'm not hearing that there's a strong push, say, that's a decision factor for a majority of the board. So correct me if I'm wrong there. In terms of, so the voter pamphlet, I heard more support for that than the voter information brochure, but, so I guess I'd be helpful to hear from Commissioner Farr and Commissioner Burney.
Maybe in terms of Mr. Dingell's question, I think I have heard sufficient interest to have you look at the question you were asking, namely, can we pay for the cost to the other jurisdictions, and is there any difficulty that might be, for me, I don't see the money as that big of a deal. I certainly don't see the liability as that big of a deal, because we've done it before, and our people are really good. And by the way, if you send in a picture to the state for your voters pamphlet, and it's got a big, Go Ducks, or in the case of Mr. Dingell, Go Beavers, logo on it, they don't call you up and say, hey, we want to make sure our voters pamphlet's right, so submit another picture. No, they just don't put your picture in. So if you don't qualify, if you don't handle it, if you don't pay the fee, if you don't observe the requirements, elections officials that put the voters pamphlet, they just kick it out. So, I'm not minimizing the work that needs to be done. I'm just pointing out that the rules are very strict and people tend to follow them.
We're losing our participants on the next item, I'm afraid.
I was just going to say, by the 29th, I will endeavor to have an answer about the payment question, and I'm sure that we will have we can get from Ms. Betchart the dates, the critical dates for decision points for the voters pamphlet. We can have that by the 29th.
You wanted to say something?
Very quickly, this is a strong no for the poll. I don't think the poll asked all the right questions. And the numbers that we got in on the basis of that poll actually lead me to be a bit more optimistic than I've heard, for what it's worth.
So, do you got enough info for today?
I think for today. I think we're good for today, and then we can come back in 2 weeks, and I think we'll get some answers on paying for the voter pamphlet, confer with the elections staff, and I think we're going to move in the direction of a voter pamphlet. Just ask the board to continue to contemplate that, because I heard more support for voter pamphlet than voter information brochure.
Well, let's bring it back tomorrow.
Okay. Well, that's fine. We can do that too.
Commissioner Bozievich, going to make a motion.
I'd like to move approval of the first reading on ordinance 1901 and setting the second reading and public hearing for 10 a.m. time certain on January 29th here in Harris Hall.
Second?
Okay, it's been moved by Commissioner Bozievich, second by Commissioner Buck to approve ordinance 1901 and set the public hearing for 10 a.m. January 29, 2019. Further discussion on the motion? Okay. Seeing none, all in favor, please say aye. Aye.
Aye.
All opposed, please say no. And the measure passes 5-0. And we are now going to go back to our adjustments to agenda and try to figure out what else needs to be done here. We've done items 2, 3, 4, 5, 6, 7, 8, and we're now down to 9 or
Be good to take care of item 13D.
13D, let's see, 13.
As it was scheduled
Oh, yeah.
for staff here.
Except I think Mr. Manello had to leave. Is that correct? Yeah, okay. So what else is not done that we could do
We've
in
been
the time?
waiting on this for a long, long time.
Yeah.
We need greater discipline at the mic here.
What would you like to do, Commissioner Farr?
Well, it's a shame that we lost our audience on this. We took too much time debating things and going back and forth. We need to have a little bit greater discipline at the mic when staff is waiting for a presentation. So we can do 13D, but I'm going to be carrying the burden of the discussion on that.
13D? Well, that was a work session on the evaluating of the car camping, and my understanding is that Mr. Manella had to leave because he had a doctor's appointment.
We have park staff here, so that's a report back on the car camping in park. So we have park staff here to,
What's your preference?
I would say since we have 3 staff here and a member of the public that are, the only folks in the audience are here for that item.
Okay.
I'd say take that item.
Okay. So let's go then to item 13D. This is our work session on evaluating car camping on county property, including selected county parks. Brett Henry of our Parks Management is here. He's our Parks Manager. And looks like Dan Hurley, our Public Works Director, is joining Steve Mokrahysky. We're sorry that Mr. Manella isn't here. You want to come up and sit down at the table and introduce yourself?
My name is Todd Bowen. I'm the Operations Supervisor with the County Parks Division.
Oh, great. Well, welcome. And so,
Sorry, I've got an appointment at 4:30, but I thought this was very important to come help.
All right.
And provide whatever I can.
would you guys might letting him give his pitch right now before he has to leave?
You know what? I will postpone it. I'll make this work. I'm just here to help answer questions for the two of them.
Okay. All right. So, Mr. Hurley, go ahead.
All right. Thank you, Chair Sorensen. Good afternoon, Commissioners. Before the holidays, the board had requested that staff return with a discussion to explore authorizing camping on county properties. We're returning today, had hoped to have Steve Manella here to discuss, from Health and Human Services, to discuss the overnight car camping program and the safe parking program. He left me a few notes, but I'm not familiar with this program at all, and so hopefully you are. Okay, great. But we also have our park staff here to talk about how a program may or may not be suitable to county parks and some of the impacts that it may have. We also have, so Todd joined us here. He's familiar with a pilot program that we tried about 5 years ago to have one unhoused individual as a park host, I believe, through a St. Vincent de Paul program. Let's see. So there's information on your packet about the specific parks we looked at and the car camping program. We understand that there's a critical need for emergency housing options in the community, but we also wanted to be thoughtful that any sort of program could have impacts on users, on budgets, systems, staff, our citizens. So for this first conversation, we've focused on parks properties. However, there are probably other county properties that you may want to consider. But the similar factors should be considered, such as cost, security, proximity to services, impact on adjacent users and uses. So with that, I'd planned to begin with Steve Manella to talk about the car camping program and the safe parking program. It's my understanding that the car camping program is a program through the City of Eugene and the City of Springfield and at different churches, and that we looked at expanding that into the urban growth boundary area, but so far we only have one church that's participating in that program. And then that's separate from the safe parking program, where at behavioral health we have 10 spaces, and the parkers there are able to be there from, I believe, 8 in the evening until 8 in the morning. So St. Vincent de Paul is contracted to help with that project to make sure that they're out on time. We provide some toilets at the facility, and I'm not sure any other resources that we provide on that. With that, I guess maybe I'll pass to Brett to talk about what you've looked at for parks, and then we can have an open discussion with the board.
Yeah. Well, thanks, Dan. So Commissioner Farr, you asked me a question at December 18th meeting that we had, and I have an answer to your question. So we have 3 parks that are campsites, but they're closed during the winter. It's Richardson, Baker Bay, and Archie Knolls. Richardson has approximately 92 sites. Baker Bay has 49, and Archie Knolls has 12.
And my question did not only pertain to parks with campsites, also parks with parking lots that are closed for the winter, for instance, Orchard Point. So, go ahead.
Yeah, sure. We could definitely get back with information on that as well. Certainly.
Okay, please go ahead.
So, yeah, I think that when we are looking at some policy issues, I'm really being directed by the master plan, and if we're going to change some use to the parks, I think there needs to be a public process that's going to occur before we make any use change to our public parks. I certainly can empathize with the situation right now, and I think there needs to be a good long study taken to this before we make any rash decisions. But certainly, if there's any information I can provide for you, I will. Goodness.
Then I'll respond to that a little bit, and there's some generalities here. We have 2 elements, 2 timing elements here. Right now, we have people who need a place to sleep tonight and next week, and then there's an urgency surrounding that. We also have a longer-term issue, and I think by looking at the Parks Master Plan and having a public process for a longer-term winter use of parks, that's certainly the case. In the meantime, however, we do have a bit of an emergency, not a bit, but a lot of an emergency, particularly this week as we relocate campers from our 99 camp. And potentially we're going to have an overflow of people needing a place to stay legally, safely, so they're not going to camp in the empty lot at the end of your street, and all your neighbors say, "Hey, county, get those folks out of here." So that being said, my request, and this came through the Poverty and Homelessness Board. The request was from the Poverty and Homelessness Board, was for us to look at innovative ways to use properties that we have. Now, in looking at what we've done in the past, we've not been very innovative in the past. And in fact, we've had some what are described as failed programs in the past, certainly. But we have a different way of looking at things today, and we have a different way of managing the way people are able to stay in certain locations. And, you know, we're not, while the 2 boat ramps that have been recommended as potential sites are certainly inside the City of Eugene's service area, we don't need to, it doesn't necessarily have to be inside of the City of Eugene's service area for some of the campers. Now, for people who have a viable, hard-shelled dwelling unit, whether it be the back of a pickup or a car or a camper, you know, that they're mobile, and they can potentially stay in places that aren't adjacent to the City of Eugene, City of Springfield, or City of Bonita service areas. So, you know, so when I asked for an innovative look at it, I wanted really to cast out all of the stops and really look deeply into how are we going to accommodate some of the folks who do need to have places to stay. Now, I'm not looking to send out an all-points bulletin saying, hey, everybody come to Lane County Parks. That's not what I'm talking about. I'm not talking about putting 25 campers in a particular park. But if we have a park that has a host already, without burdening the host, we do have a system in place there where somebody is using the park, and presumably whatever sanitation facilities are necessary for the host to live there. I don't have the answers completely to this. Well, I have my answers, and I'd like to, I could write a program right now, but really that doesn't fit within the parameters of how you operate the parks. So that being said, what I asked for was an innovative look at how can we use county properties to house people for this winter, and an adjunct to that is let's take a longer look at how do we do this for the future. Because these properties they're fallow, they're not being used right now, and they could be used by some people without degrading the public use of the property during the rest of the year. So that's what I asked for. I don't think I got it. So, you know, if we're looking at alternatives and options, option 3, do not explore further options. That's not an option for me. I think I stated that fairly clearly.
Would you like to add anything? I know you have to go, and I want to make sure we get your perspective on this.
Well, I'm just here to try to, like I said, to support and answer the questions that might come up. For instance, where these campgrounds that we have a caretaker currently staying there, basically our campgrounds are built for, these ones that we close during the winter are simply just that. They are built to operate during the summer. So the one campground that we do have that would be within the city limits I'm thinking of would be Richardson out there. And one of my biggest concerns with that is the public water system is not built during the winter to support that kind of use during the summer. Basically, Orchard Point and Richardson together during the summer are tied together. Both wells feed a big tank up the hill due to the bridge across the Long Tom River is not insulated. So we shut that system down during the winter, and it's solely ran just by the Richardson pump that only pumps 7 gallons a minute. So the time that you open them campground restrooms and stuff like that and provide water to all these other campsites, that water system is just not able to take care of it. Nor is the sewage lagoon. We shut down the sewage lagoon. It's been a problem for us for 20 years on just the capacity. It's at its max limit, and you keep putting wastewater towards that. That's another problem that we have to face during the spring on how do we get that pumped down enough that we can open up our parks during the summer when we're normally open. Them are the things that I've got going on. I'm going, how are we going to provide that?
And thank you. That is a condition that exists, and I would not prescribe that we do reopen the water system. However, there are other alternatives for people to get fresh water, holding tanks.
There very well be, yes.
And there are also other alternatives for sanitation. We use them elsewhere. We use them in other camping situations where people they bring their fresh water. They use their fresh water and use their holding tanks and for gray water, but they also have a Bucks sanitation unit. So we don't need to open the water system. We don't need to open the sewage system. It can be done in a self-contained fashion. And that's the type of innovation that I was asking us to take a look at, is how can we do it without placing the impediments or the strains, the stresses on your system that I don't want to ask you to do.
I also want to mention some staffing concerns. As you know, we're understaffed as it is, and taking on that additional workload is something that would have to be explored to keep the parks safe to the public. So, you know, it's a matter of magnitude of what we're talking about here. And so, as far as an additional number of people that would be staying overnight at our parks, in our parking lots or at the campsite. So there's a staffing concern as well that I want to mention.
And that is, Mr. Chair, thank you. That is a condition also that I would not wish for you to have to address. The innovative solution would be self-contained campers who don't have staffing needs. That they're the same folks who ultimately may stay in other camping spaces, like in church parking lots, that they do take care of themselves. Thank you, Mr. Chair. I may have more questions. I think other people are entitled to questions. Thank you.
I was just curious if this was addressed in any way last year during the Parks Master Plan. I wasn't sure if.
It was not.
it
And
was
in
touched
fact, it was a surprise. So there was a person in the audience here that heard this and was very upset that this was being proposed without input. So I think Brett's comment at the beginning is just that we want to be cognizant of not wanting to surprise our park supporters. I mean, we went through a situation with, Kaleidoscope and backlash from the public that we would like to work through a thoughtful process if we're going to be considering this for our parks. I think we can have some conversations here now, but if we get traction on looking at specific parks, we would want to go back to the Parks Advisory Committee as a starter and start having those conversations. But Commissioner, you asked for innovative solutions. I'm not sure that we need, something innovated. What I was hoping to have was Steve here to talk about the existing program and how that is successful. And my hope was that we could just then replicate that. And so I think that would be a fairly low impact a program, because there are self-contained toilets. We're not providing water. It's more of the issues of security, whether we would contract out and who would bear the cost for those. And then looking at the sites, does it make sense? We have 63, 68 parks. Most of them aren't suited to serve a need. We probably want to look at parks that are closest to the urban center where there's a need and where these individuals can receive services. It doesn't make sense to have them drive with their limited.
Why don't we finish at least one round for the commissioners? Yep, go ahead, sir.
So my understanding is there's a loop of Armitage that you guys don't open up in the wintertime because of lack of demand. Is that an accurate statement?
Not at this time. There was a back loop around some of the older trees that we shut down for maintenance staff, made it easier for us to go in and blow all the leaves without people camping in there. Since about last year, it is so busy in there, we keep it open now.
Okay, all right.
We kind of.
That's old information in my head, okay?
Yeah, and I think it was something that we took off the reservation system, but yet overflow always trickled over to it. That campground is pretty much busy.
It's been discovered, yeah.
Okay, yeah, so, sorry, because one of the reasons I was interested in that one was it meets the criteria of being fairly close in on a bus line, and it would really be an advantageous use of that. And it's close enough in. The second part of my question is, and I'm sorry Steve's not here, but we allocated when we started the pilot in the urban growth boundary of Eugene, we allocated about $45,000 for the contract with St. Vincent de Paul for up to 10 campsites. We've only used one, so there must be excess capacity in that contract that maybe we could amend the contract with St. Vinny's to cover something that's close enough in. They're not going to go to Veneta or beyond like Richardson for that under that $45,000 contract. But if we can find some place close in, we might be able to get. And part of that is that they manage a list, and they pre-screen. And of course, sorry, Heather, but because this probably means you're going to have to recuse yourself. But they pre-screen the list. They manage that list, and the folks that we're going to host have to have some kind of at least support and case management. The idea that we're going to cite somebody out at Armitage with the Bucks and their own water supply and not need some kind of case management, I think is a little short-sighted, because you're setting those folks up not for success. And that's the whole point of the car camping program, is you hope there's case management attached to it to get people beyond car camping and into something more permanent. You know, it's an emergency thing we want to do. So, you know, if there is, and it may not be Parks property, but if there is county property that is close enough into the Eugene Springfield area where we might be able to amend our contract with St. Vincent de Paul, and if it takes maybe some kind of emergency, if it's outside the UGB, it might take an emergency amendment to our code to allow that car camping, because we've only made a code amendment inside the UGB. So that's you know what we're dealing with here somewhat. But I think the real possibility we have in front of us right now is we didn't utilize that pilot fully. And if we can find something close enough in, we might be able to utilize some of that pilot resource for this program. So the question is, you know, and I know that there's been some work done to look at county-owned properties. So I'm looking towards Steve here.
I do have a response to that.
Okay, did you want to say something? Okay, go ahead.
Tomorrow, to that point that Commissioner Bozovich brought up, tomorrow we will be implementing an additional 10 car camping spots at the MLK property managed by St. Vincent de Paul. So we've coordinated with, you're absolutely right, that St. Vinny's is part, this isn't, you know, it's not as simple as just identifying a parking lot and then saying people can camp there and putting some porta potties and hand washing stations. It really does require some coordination with a social service agency like St. Vinny's. So we've worked with St. Vinny's. Tomorrow we will be opening those additional 10 parking spaces under the Safe Parking Program. And we're working with campers at the current Camp 99 as an option, as well as others. St. Vinny's is a similar process where they have a list of folks that they ask to get signed up through there. I will also say that if you read the Register Guard article about the Camp 99 move in the paper today, there was a picture of two individuals, I believe, embracing. Those two individuals are a couple. The one has a disability. The other has two jobs as a bookkeeper in Cottage Grove. They've been living at Camp 99. They have 3 dogs, and so they don't qualify for the St. Vinny's options. And so we've worked with the advocacy community and our staff and identified and work with Public Works and identified a camp spot at Armitage Park. We're paying for that camp spot. So they are paying campers at that location, and they're looking for about a 2-week period of time, because they're highly functional individuals, save the disability and the other challenges that they're facing. So we are trying to look at sort of creative solutions that work, but your point is absolutely right that, you know, putting individuals at a park, it does still require the need for, you know, for some mobility and the proximity of the park or a vehicle so that they can get transported.
Okay, anything further? Yes, Commissioner.
I just want to say that I believe this new Board of Commissioners is going to align behind Commissioner Farr as it relates to homelessness as a priority. I believe that while we look for creative and new solutions that don't impact, right, what we've got going, I second his request to if the parks can be a partner in a way that isn't negative and in a way that in fact can be more self-contained, I would really welcome to hear your thoughts on that subject. Not right this moment, but you know what I'm saying. Unless you have some now.
Years are turning.
Yeah, okay, very good.
I guess I'll summarize this by saying I don't think that we are done with this work session. I think we need to continue the work session. I don't know if Mr. Manel is available tomorrow, so I don't want to commit his schedule to it, but perhaps Ms. Jones or Mr. Mokrice could find out if he's available so we could continue this discussion tomorrow, because I do think it's an important one. Secondly, assuming the board wants to move in this direction and look for a win-win where a county park is the security is increased by having people there. And there is less vandalism when people are there and they are given some sort of training. I personally went to the workshop that a provider put on about the city of Eugene parks system and how they were going to have homeless people with vehicles. So you could not be a homeless person with a tent. You had to be a homeless person with a trailer or camper. But they had a program to train these people to assist park staff in making sure that there wasn't vandalism and that they had proper procedures of who to call if there were problems. They weren't law enforcement. They weren't that wasn't their job, was to arrest people or shoot people or otherwise detain them. But certainly having some people around was a big help to the park. And again, it has to be matched with the proper person. And that's why I think Mr. Manella's side of the house is an important part that we could have. I guess I would also say that there might be land use implications, and for Mr. Hurley, the LMD side might come into effect if we talk about areas where the county has land use jurisdiction. And last but not least, I totally agree with Mr. Henry that we've gone through a multi-decade process, more recently a multi-year process to get a Parks Master Plan, and that we need to make sure that we are making sure that we're in compliance with it, and if we're not, that we have a public process to make sure that it's going to go smoothly. But I do think there is a sweet spot here, I really do, where if there's money, and money is always a drawback when we're talking about the Lane County Parks Division, but if other money comes from social services to help us maybe address some parks issues in terms of safety, vandalism, and it also helps helps, make progress towards helping homeless people. It wouldn't be great if we could put it all together. I don't think we're going to finish that today. And I guess I'll call on Commissioner Farr. What do you think of the idea of continuing this work session when Mr. Manel is available?
Well, I'm okay with that. I think we're probably close to a conclusion. I don't think we're going to solve anything tomorrow either regarding an actual solution that's going to open some more parks. However, continuing the discussion at some point, as I mentioned, Mr. Chair, we have two issues. One is the immediate issue for this winter, and the second is a longer-term issue, which is going to require a public process. But I think, Mr. Mokrajewski, you'd mentioned that we're adding 10 spaces adjacent to LCBH. That is a response, and that's going to take care of some of the issue. But if, Mr. Chair, if we were to go back to the options, what I would state on the option is that we conclude the discussion today, but request that both 1 and 2, the staff continue to explore options for car camping at selected Lane County parks, and that we continue to explore options for car camping at other Lane County properties. And an example of another Lane County property is the large parking lot, is a paved parking lot in kind of disrepair adjacent to the Armory, which is adjacent to LCBH. It's where the University of Oregon fans tailgate. It is paved. It's not very well paved. It's pretty bouncy and dicey. It is adjacent to LCBH, but it's not inside of the LCBH parking lot. That's another example of a paved place that is relatively discreet in its location that potentially could be used with a minimal additional burden for the people who are monitoring the parking program for us. So that's an example. So my request, Mr. Chair, is that we continue to explore options for both selected Lane County parks and other Lane County properties, and that we bring it back in at your discretion with the agenda committee.
Okay. I guess I would like to, first of all, agree that we ought to keep talking about this and keep the work session. Have you talked to any parks managers where there's been a innovative connection between social services and parks to work on what I would call a happy meeting of the minds here and helping the parks and helping the people?
Chair, I was going to mention that next. I can follow up. I can look at some other jurisdictions and see, how they were able to implement such a program and then compare it to our current park system and see, if there is a sweet spot and report back to the board, if that would be.
You might look at Clackamas County, which is a semi-urban county.
Certainly.
Okay, anything further? And I guess at this point, we will say we are going to conclude today's work session, but we'll have another work session maybe when you report back and you have some information. What's a reasonable time for us to expect that? A month, 2 months, or next week? I mean, I don't want to tell you what a reasonable time is.
Yeah, maybe a month. I mean, I think what you heard from staff was we are feeling like we need to do a public process. So I guess identifying where there may be feasible locations with it, at least in parks, and then going through some kind of a public process. I'm just struggling with what we would bring back in a week or a month, other than the update from Mr. Manila. But I think his update was essentially going to be 10 additional car camping spots available tomorrow, and as well as an update on, I believe, one church that has partnered with us and taken advantage of the UGB car camping program. So, sorry, I guess I'm struggling with this is obviously something that needs to be continue to be worked on in the context of all of the other things we're doing around housing and homelessness, the permanent public shelter, the supportive housing work, the grant programs. So why don't we confer on when this can come back? We'll put it on the assignments list and can discuss it with the agenda team.
Okay.
And I'll be providing a report to both the Poverty and Homelessness Board and to the Shelter and Supportive Housing Committee this week, to not necessarily happy audiences, because we were expecting a greater response in this, but I understand the conditions that you're outlining. So, and regarding the two boat ramps, Whiteley and the other one, probably adjacent to a flowing river may not be the best option.
Okay, any further comments, Commissioner?
Stephen, in reporting back, you said you'd get back to us on the parks, and I think we agreed that it would be alternatives 1 and 2, so does that also
Parks
include
and
other
other
Lane County?
properties.
Okay, thank you.
I will tell you, in the almost 5 years now that I've been here, we've probably developed half a dozen maps of county-owned properties, and so we certainly can do that and maybe have more of maybe we need to do a work session with the board that's focused on this conversation and looking at properties so that there's a clear understanding of the opportunities as well as constraints. A lot of our county-owned properties are right-of-way. They're road fund right-of-way properties that are not, you'd be putting.
Most are not paved too.
Right.
I think that's a consideration.
Yeah, but why don't we make that part of the assignment that we'll come back for a work session with the board and have a broader discussion that encompasses all county properties in addition to parks.
Thank you.
Okay, thank you very much. Appreciate you coming in and waiting for our discussion. Okay, let's go back to the adjustments and again see what we've covered and what we can cover in the remainder of the day. Have we done everything through 9A? Are we down to, we after Commissioner Bozievich set this agenda, Ms. Jones and I discussed briefly that we were going, we might have trouble meeting this agenda, so we put on the appointments tomorrow as well as today to make sure we had that covered. So do we want to do that tomorrow, or what's your preference? I remember when I first got on this board, Steve, another Steve, Steve Kornakia was the chair, and he said he totally did not want the board ever to go past 4 o'clock because people's attention spans and they got to get places and do things. So I'm just looking for guidance from any of you, if you have to go someplace, if you want to just keep going, how you feel about it.
A 5:30 meeting other than that.
5:30? So do you want to try to go recess now so that you can go to your 5:30, or?
Well, it's Community Health Council, and it's just a few steps away from here, so
Okay.
I'm fine going on.
Okay.
But,
I'd like to try to keep us on a 9 to noon, 1:30 to 4:30 kind of timeline on Tuesdays and Wednesdays so that people have that kind of plan down. Any comments?
My only comment is I'm concerned with the way the board meeting's gone for the last couple of weeks, in that I think we haven't been very respectful of staff time. When we post an agenda, staff looks at that agenda and kind of makes sure they're available in the approximate times of when the agenda item's going to occur. And as we continuously get behind in our agenda and move stuff around, we're creating havoc in the staff's world. As much as we can do to try and get back on track with when the agenda's posted, it was probably not a bad thing for staff. I don't know that there's a lot of staff involvement in our discussion items around committee assignments. That's really an internal board discussion, so moving that around seems to be fine. If we end up doing that tomorrow afternoon, I do have a 4 o'clock commitment tomorrow afternoon, but that's about it. Whether we try and deal with commissioners' business now or not, we can't move, of course, tomorrow morning's ethics is a time certain, basically, and so is our executive session time certain that staff has set aside. So just the question is whether you want to start diving into board assignments at 4:20, or you want to dive in those 1:30 tomorrow. But we're also pulling, Mr. Mokrzyski's time, and he's got a county to manage. So I hope we can be a little bit more respectful of staff time in the future.
Good, okay, so I'm kind of hearing that we should call it a day now and come back and do the work session with the ethics, the executive session, which is going to be close to 2 hours. We have a recess planned, and because of television and boardroom, so that starts at 2:30. I'm sure we'll be done with the various action on the appointments, and then the county the announcements by commissioners and agenda team requests. So I think we'll be able to do everything tomorrow pretty easily. Does that look okay to you?
which time window tomorrow?
I was just going over what I envisioned tomorrow would be as laid out by the agenda that Commissioner Bozovich put together. We'll have the work session with the ethics people coming down from Salem. That's a 2-hour presentation. Shortly thereafter, we'll morph into our executive session for the board, and the county council wants to talk with us about overview of litigation, I believe. Then we come out, and we at 2:30, we have our discussion of the appointments. We have the commissioners' announcements, and we have the agenda team review of assignments, and we're done.
The Mental Health Advisory Committee meets at 2:30 tomorrow, so.
Okay. And again, I envision kind of a process of 2 days, and you're right, we can do things to speed things up. We can not give people 5 minutes like I did today at a public hearing. We can give them 3 minutes. We can give them 2 minutes at a public comment. We can enforce a one-time through policy. I'm open to any ideas that the board wants to do to speed things up. But we also have some commissioners, myself included, that want to get things done, want to do things, and having that work session on the parks is really important, really important, so. Okay, so hearing nothing further, then, or,
I'm
yes,
sorry.
go ahead.
Steve, don't we have a meeting at 1:30 tomorrow?
Yeah, we're,
Yes, we had scheduled a meeting at 1:30 on the community benefits agreement.
Yeah.
yeah, and then that would, the agenda that's laid out was.
Would enable
was
that?
Enable that, because we think that'll be a 2-hour meeting from 11:30 to 1:30.
Okay,
So we will have an hour break.
thank you.
Yeah.
And I concur with the points Jay made, the points that Pat has made. Anything we can do without interfering with the quality of discussion to speed things along is probably, and to be cognizant of staff time is probably a good thing.
All right, so we're going to be in recess then until tomorrow morning, and we will take up the remaining items on the agenda that were not taken up today, as well as things that are on the agenda for tomorrow. So, hearing any further comments, we got a game plan for tomorrow. Okay, very good. We're in recess till tomorrow morning.